Thank you. So we'll now resume to item 19, but before we do so, I'll turn to Parliamentarian Johnson to reestablish a quorum.
Yes, good afternoon. I will begin with the roll call to determine attendance with Chair Moore,
Present.
Vice Chair Brown.
Present.
Vice Chair Brown is present. Member Bradford. Member Bradford is present. Member Grills. Member Grills is present. Member Holder. Member Holder is present. Member Jones Sawyer. Member Jones Sawyer is present. Member Lewis. Member Lewis is present. Member Montgomery Stepp. Member Montgomery Stepp is present. Member Tamaki. Member Tamaki is present. Madam Chair, there are 9 members on the task force, and the number needed for a quorum is 5. The number present is 9. Madam Chair, a quorum has been reestablished.
Thank you, Parliamentarian Johnson. Before we resume to item number 19, I want to acknowledge California State University, Sacramento. During the break, you might have seen a slideshow around the historical worldview timeline of reparations. That presentation was again created by the California State University, Sacramento. It's a timeline of reparation movements between 1783 to the present in the United States, recognizing that reparations as a way to acknowledge and compensate a group that has been harmed is not new or unique around the world. So thank you so much to the California State University, Sacramento, and the California Secretary of State for organizing this visual exhibit for us. Okay, so the next item on the agenda is item number 19, which for me is presenting on this idea of an independent California American Freedmen Affairs Agency. Next slide, please. You can continue to the next slide. Next slide. Next slide. Next slide. Most of these slides are about a comprehensive overview of the task force and our work, or at least the beginning slides. So that's why I'm saying next slide. And you can find these presentations on my personal website, CamilaMoore.com/education. I've created a master PowerPoint and PowerPoints for each chapter in the report. Next slide. So just so that everyone is on the same page, all the task force members, we know all of this information in terms of the interim report very, very well. So this is really for members of the public, for folks to understand the thesis around the interim report. All of this information, again, you can find in the executive summary of our report. For instance, in 1863, Abraham Lincoln signed the Emancipation Proclamation, and in 1865, the 13th Amendment to the U.S. Constitution commanded that neither slavery nor involuntary servitude shall exist within the United States. In supporting the passage of the 13th Amendment, its co-author, Senator Lyman Trumbull of Illinois, said it is perhaps difficult to draw a precise line to say where freedom ceases and slavery begins. And so decades after, via the civil rights cases, you have the US Supreme Court helping Congress to interpret what the 13th Amendment meant. In 1883, the Supreme Court interpreted the 13th Amendment as empowering Congress to pass all laws necessary and proper for abolishing the badges and incidents of slavery in the United States. Next slide. So that begs the question again, what are the badges and incidents of slavery? What does it mean? We heard, for instance, in September from constitutional law scholars like Jennifer Mason McAward, who provided expert testimony on the question of what are the badges and incidents of slavery. Since Congress has abdicated its responsibility in terms of defining what the badges and incidents of slavery are, there are 13th Amendment constitutional scholars who have done this work for Congress. And again, expert witnesses like Jennifer Mason McAward have defined the badges and incidents of slavery as referring to public or widespread private action aimed at any racial group or population, this next part is key, that has previously been held in slavery or servitude that mimics the law of slavery and has significant potential to lead the de facto reenslavement or legal subjugation of the targeted group. Next slide, please. And so again, this language is lifted directly from the interim report in our executive summary, where the thesis, again, of this 500-page report is as follows. Throughout the rest of American history, instead of Congress abolishing the badges and incidents of slavery, the United States federal, state, and local governments, including California, have perpetuated and created new iterations of these badges and incidents. The resulting harms have been innumerable and have snowballed over generations. And so our nearly 500-page interim report, as we all know, focuses on these harms, with the acknowledgement that so thoroughly have the effects of slavery infected every aspect of American society over the last 400 years that it is nearly impossible to identify every single badge and incident of slavery, to include every piece of evidence or describe every harm done to African Americans. And so again, the executive summary concludes by saying, in order to address this practical reality, the interim report describes a sample of government actions and compounding harms that have resulted in 12 specific areas of systemic discrimination. Next slide, please. And so as we all know, after the enslavement chapter of the interim report, there are 12 remaining chapters that are organized around those 12 major specific areas of systemic discrimination that the task force is calling badges and incidents of slavery, from racial terror to political disenfranchisement, housing segregation, separate unequal education, racism in the environment and infrastructure, pathologizing of the Black family, control over creative, cultural, and intellectual life, stolen labor and hindered opportunity, the unjust legal system, mental and physical harm and neglect, and the last chapter is on the wealth gap. Next slide, please. So I'll go through these slides quickly, but just to give you a sampling again of the badges and incidents of slavery that this task force is tasked with coming up with recommendation proposals to eradicate or eliminate. The first chapter is on enslavement. As we all know, despite California entering the Union in 1850 as a free state, its early state government supported slavery. The images you'll see in these slideshows are also directly from the interim report, like this African-American miner posing with the shovel at the Auburn Ravine during the gold rush in 1852. Next slide. So after the enslavement chapter, again, describes the different badges and incidents of slavery that still linger on and negatively impact the African-American or American freeman community. Starting with racial terror, we can look at California. As we know through our interim report released in June of last year, the Ku Klux Klan, for instance, established local chapters all over the state in the 1920s. During that time, California sometimes even held more KKK events than Mississippi or Louisiana. Next slide. We talk about political disenfranchisement. This picture is from our interim report. Rayfield Lundy, a Republican candidate for the California 55th Assembly District, inspects a burnt cross at 1816 East 122nd Street in LA. A lot of folks don't know that California prohibited individuals convicted of felonies from voting, added a poll tax, and put in place a literacy test. Next slide. The next badge or incident of slavery of the task force is tasked with coming up with final reparation proposals around is housing segregation. A lot of people don't know, but we learned together via this interim report that, like elsewhere in the country, white Californians use violence to enforce the racial hierarchy created during slavery by preventing African Americans from moving into desirable white neighborhoods. And this is a picture from the interim report of William Bailey and Roger Duncan in 1952 in their living room after a bomb exploded in the house. Duncan's house directly across the street was also bombed at the same time, and a note was left threatening all the Black families on the street if they didn't move out. Next slide, please. When we talk about the next badge or incident of slavery, separate and unequal education, in California, California remains the 6th most segregated state in the country for Black students. Next slide, please. The next badge and incident of slavery the task force is mandated to address is racism in the environment and infrastructure. National patterns are replicated in California. Black Californians are more likely than white Californians to live in overcrowded housing, near hazardous waste as well. Compared to other Americans, African Americans are 75% more likely to live near hazardous waste or refining facilities. Next slide, please. The next Badger incident of slavery is pathologizing of the Black family. California trends in the child welfare, juvenile justice, and disciplinary action in schools match those in the rest of the country. Recent California Attorney General investigations have found several school districts punish Black students at higher rates than students of other races. Next slide, please. The 9th chapter of our report is on control over creative, cultural, and intellectual life. Some of the key findings from that report, that chapter, in California, city governments decimated thriving Black neighborhoods with vibrant artistic communities like the Fillmore in San Francisco. State-funded California museums have excluded Black art from their institutions. California has been home to numerous racist monuments and memorials for centuries. Again, this picture is from our interim report of Little Richard protesting record companies over royalties. Little Richard said the rights to the song Tutti Frutti, he sold the rights to the song for a mere $50 and received half a cent for each record sold. He said, "I was a dumb Black kid, and my mama had 12 kids, and my daddy was dead." Little Richard reportedly said, "I wanted to help them, so I took whatever was offered." This was in 1984. Next slide, please. The 10th chapter, the Badgett incident of slavery, we're tasked with addressing is stolen labor and hindered opportunity. We found in California, several California cities did not hire Black workers until the 1940s, and certain public sectors continued to avoid hiring Black workers, even in 1970. The San Francisco Fire Department, for example, had no Black firefighters before 1955, and by 1970, when Black residents made up 14% of the city's population, only 4 of the department's 1,800 uniformed firefighters were Black. To the right is a picture again from our report around the annual income during the Great Migration of white immigrant workers versus Black workers. You see Black Americans who descend from slaves had the lowest annual income compared to newly arriving European immigrants. Next slide, please. So the next Badger incident of slavery we're tasked with addressing is an unjust legal system. Like the rest of the country, California stops, shoots, and kills and imprisons more African Americans than their share of the population. Data shows that law enforcement most frequently reported taking no further action during a stop with the person they perceived to be Black, suggesting there may have been no legal basis for the stop. African Americans are 3 times more likely to be killed by the police. There's also an 88% increase in anti-Black hate crimes from 2019 to 2020 on a federal level, and Black Americans are the #1 victims of hate crimes in the city of Los Angeles, for instance, the entire state of California, and nationally as well. Next slide. The next Badger incident of slavery we're tasked with addressing is mental and physical harm and neglect. This picture is from our report, Students at the University of Maryland School of Medicine in 1898. The English sociologist Harry Martineau wrote in 1838 that the bodies of colored people exclusively are taken for dissection because the whites do not like it and the colored people cannot resist. So this is a picture of an African American woman being dissected by white male medical students. And if you look at the engraving on the table, it says, "Her loss is our gain." And so nationally, the government actions described in our interim report have had a devastating effect on the health of African Americans. Compared to white Americans, African Americans live shorter lives and more likely to suffer and die from nearly all known diseases and medical conditions compared to white Americans. And in California, the life expectancy of an average Black Californian was 75.1 years, 6 years shorter than the state average. Next slide, please. And lastly, the last chapter is on the wealth gap. The late Reverend Martin Luther King Jr. said this as much in one of his last speeches, right? While Congress refused to give the Negro any land, at the same time, through an act of Congress, was giving away millions and millions of acres of land to white immigrants to undergird its white peasant class. And so nationally, federal and California Homestead Acts essentially gave away hundreds of millions of acres of land almost for free, mostly to white families. Today, what are the present day implications of that? Our report found that as many as 46 million of these white living descendants currently reap the wealth benefits of that land transfer via the federal and California Homestead Acts. That's nearly a quarter, or 25% of the white adult population still benefits from those land transfers. Also, when you look at the wealth gap in California, well, more particularly Los Angeles, since there is no state data on the wealth gap, a 2014 study of the LA metro area found that the median value of liquid assets for native-born African Americans, or those who descend from slaves, was a mere $200, compared to $110,000 for white households and $72,000 for African blacks of immigrant origin. And so, again, this is from our report. In 2019, white households owned 9 times more assets than black households. Next slide. And so, as the interim report has stated, it's nearly impossible to identify every single harm or atrocity done to this special and unique group of people that are Black Americans who are descendants of slaves. We tried our best in our nearly 500 pages to, again, identify the 12 major areas of systemic discrimination or badges or incidents of slavery, as constitutional law scholars have defined, that still impact this special and unique group of people. And so this huge, magnanimous problem really mandates a comprehensive solution. And so my presentation concludes with, again, a potential final proposal to create an independent new agency called the California American Freedmen Affairs Agency, which mission would be to provide perpetual special consideration to descendants of American slaves or American freedmen in California. The agency will primarily provide reparatory justice services and programs directly to the descendant community. Next slide. Just very briefly, we know that there was once a Freedmen's Bureau in this country on the federal level that provided provisions, clothing, and fuel necessary for the immediate and temporary shelter and supply of destitute and suffering refugees and freedmen and their wives and children. This agency had the authority to supervise labor relations in the South with the mandate to provide education, medical care, and legal protections for formerly enslaved African Americans, along with the authority to rent out and eventually sell allotments of abandoned or confiscated land to free African Americans. Next slide, please. And so the original goal of the Freedmen's Bureau Act, which was enacted yesterday in 1865, that was the anniversary. The original goal of the Freedmen's Bureau Act was a more radical notion of allowing African Americans the means to become self-sufficient. In closing days of the Civil War, for instance, General William Tecumseh Sherman issued Special Field Order Number 15, setting aside 400,000 acres of confiscated land for those who had been freed. Let's see. However, in less than a full harvest season, the land that Sherman had given to freed persons was returned to their prior owners. Next slide. And so, although the Freedmen's Bureau tried to assert and protect the rights of formerly enslaved, it also perpetuated racist stereotypes, we have to be honest, paternalistic attitudes, and continued to limit African Americans' economic and social power. Again, this language is from our interim report, where we talk about the history of the Freedmen's Bureau. Bureau agents often viewed formerly enslaved African Americans as children, unprepared for freedom, and needing to be taught the importance of work and wages. The Freedmen's Bureau abandoned the possibility of land reform in the South and focused mostly on labor relations between Black and white Southerners instead. I wanted to include this language again just to be honest about the history. The Freedmen's Bureau was not perfect, but the idea around creating a state agency on the state level, particularly for descendants of American slaves, is still noble, and it's important for us to learn from this history and improve on this history. Next slide, please. And this is just, for instance, to show the providence around the terminology of freedmen is evident, right? You have prominent folks, for instance, from the LA Times, just as recent as February 22nd, that wrote around Allensworth, right? California's first freedmen town. We have a report on Allensworth and Freedmen's Towns in our interim report as well. Next slide, please. And so in terms of the specifics around the functions of this proposed agency, again, it would provide services to the descendant community through contracts, grants, or partnerships with community-based organizations, private entities, and other local, state, and federal agencies, with obligatory oversight and auditing by the agency's Office of General Counsel and its Chief Financial Officer. Again, its primary function would be to provide direct services to the descendant community, but again, additional functions would also be to work with these different entities via a strategic partnerships branch. Other functions of the agency would be to identify how past state-sanctioned atrocities have perpetuated and created new iterations of badges and incidents of chattel slavery. Other functions would also be to work with the aforementioned entities that I mentioned to eradicate any lingering badges and incidents, including existing agencies, and to suggest policies to the governor, state legislature, and other entities designed to repair the descendant community for these badges and incidents. Next slide. And so the proposed agency would be comprised of specialized offices and branches dedicated to assisting with the implementation and operation of policies and programs being considered for recommendations. These would include, for instance, so again, there would be obviously, like any other agency, an Office of General Counsel, Chief Financial Officer as well. There would be an Office of Strategic Communications, which would house, for instance, a strategic partnerships branch that would work with, again, existing state agency, community-based organizations, other public or even private entities. There would be a community support branch in light of what UCLA admin law professor John Michaels alluded to in his expert testimony yesterday. And then, of course, there will also be reparatory justice branches that, again, would provide direct reparatory justice services to the descendant community, like a genealogy branch, Office of Immediate Relief, civic engagement, or self-determination, and that alludes to the political disenfranchisement chapter in our report. Next slide. There would also include, for instance, an education branch, social services and family affairs, creative, cultural, and intellectual life. Next slide. There would be a legal affairs branch, a medical affairs branch, business affairs branch. And again, all these proposed reparatory justice branches would, again, provide direct, tailored, unique services to this unique and special group of people. Next slide. There would also include a housing development branch, which I think was recommended by Demlish Johnson, who gave expert testimony via the city of Richmond yesterday, and a data and research collection branch. Next slide. Next slide. Next slide. Next, okay, so that's the end. I wanted to conclude by saying, or uplifting a quote, when we look at the legislative history of the Freedmen's Bureau, right? You have Congress people who, in creating the Freedmen's Bureau, said, you know, these people deserve some permanent redress, not necessarily because they're Negroes, but because they come from a people who have been despoiled of their rights for centuries. And so that's what the spirit of this new independent agency would be. It would be a permanent place, space for this unique and a group of people to get the services that they've been denied and despoiled of for centuries. You know, Dr. W.B. Du Bois said the same thing, right? There needs to be a permanent space or place, similar to the Bureau of Indian Affairs or even the Office of Immigrant Affairs, you know, a place and a space for African Americans who descend from slaves to achieve their full citizenship rights under the 13th, 14th, and 15th Amendments. And so that is the end of my presentation. You know, I implore the task force to entertain a motion around not the creation of a oversight commission, but to entertain a motion around the creation of a new independent, full-service agency, again, for African Americans, American freedmen, for this special and unique group of people who deserve full, direct reparatory justice services. I think that's the only way we can really make sure that this 2-year effort that we've been on, matters. That's the only way we're going to be able to make sure that our work that we've done is not in vain. Thank you. Yes.
Madam Chair, I move the adoption of your presentation and the action therein indicated.
Is there a second? It's been properly moved by Vice Chair Brown and properly seconded by Member Montgomery Steppe that the task force adopts the proposal to create a new independent agency tentatively titled the California American Freedmen Affairs Agency. Is there any discussion on the matter? Member Bradford, you're recognized.
I'm a little confused because,
Could you please speak into the microphone?
yeah,
Thank you.
I was sharing that I was a little confused because our last meeting, we actually had a motion and a vote by the task force to have an agency, but that agency would not try to perform all of the duties that are listed there. It's an incredibly intense bureaucratic effort, and it does not necessarily include the participation of other entities like community-based organizations that have been doing the kind of work that is being proposed for decades within our communities and are known and trusted. So again, I'm not saying that I'm against the agency, but I do believe we did have a vote to scale back the scope of what this agency would do.
Oh, under my
Madam,
understanding.
I'm sorry, just to clarify what was just stated, you are correct in terms of what occurred at the last meeting. To the extent that there's a conflict, this motion would have to be clarified that you're talking about things that are not in conflict, and that would require you to go back through and distinguish what was done at the last meeting so that the members know what is subject to being voted on at this meeting or at whenever you vote on it.
The motion stands on itself, what I made.
I can't hear you, sir.
The motion that I made stands for itself. We're not talking
Your
about
motion was an encompassing motion that took into effect what was already done. And if you have a conflict, you'd have to make sure that they're aware of that conflict. Because this motion was for the entire report, the way I heard it. And if that is true, then it has some things in it that would, if passed, override what was already adopted, which may not have been her intent. So and what I just heard was that was not her intent. So if there's some conflict or confusion, you don't want to vote on it unless you know what you're voting on. That's all.
Okay, so to clarify, excuse me, Member Grills, if I misunderstood, but I thought the motion last month was it was around how community-based organization would be involved. It wasn't, to me, I didn't think it was a vote to scale back this idea of an agency. And I think that's why we brought in, or the DOJ brought in, Chris Alamo yesterday to talk about the distinctions between an oversight commission or a newly independent agency, because there was still a discussion to be had about the direction of this proposed agency.
Mr. Alamo spoke to the distinction between a commission and an agency in response to a question that I posed to him. about the extent to which there's any real teeth in a commission. And then he gave a nuanced, appropriately nuanced answer. It depends on the commission and the work before them.
So I think, let's just be honest, the motion on the floor that Vice Chair Brown proposed is to, I guess, override what your interpretation of what occurred last January.
Well, it's not my interpretation, it's in the minutes.
Okay, well, that's on the floor. The motion is to override the motion that you introduced last January.
Okay, do you all have a copy of the language from last month, of the last meeting where you voted?
Yes. Page 23 and 24.
It was in the minutes,
23 and 24.
pardon me?
Page 23 and 24 in the minutes.
Say it into the mic.
Sorry, pages 23 and 24
them.
in the minutes.
Yeah, I've got it. I want to make sure that you, the members, know what it is that was voted on before and what was stated this time. The last motion said it was moved to state the proposal in a motion with a modification to the role of the Freedmen's Bureau. Freedmen's Bureau, and we have to distinguish between a bureau, an agency, department. So we want to make sure what you're doing is what you intend to do. Okay, so that's the one thing. The number two is that it's to really clarify what the role of the bureau will be, or it's identified here as a bureau. So you've identified it as a bureau. You may not want that, but you need to clarify that. The second is that to act as an oversight and monitoring body rather than as a bureaucracy. In other words, rather than as an overall agency, as an oversight entity. So I don't know, based on what was stated, and there's a lot of information in what was presented today. So we want to make sure, this is pretty significant, wouldn't you say? So, we want to make sure that what everybody, you may understand it, Vice Chair Brown, but I want to make sure everyone is clear.
I think my motion was palpably clear, and the motion was that this agency would be established. Now, regarding community-based organizations, that's not a part of the motion.
I'm sorry, what?
That's not a part of my motion.
What is not a part?
About community-based organizations.
Let's, for the benefit of everyone here and the public, let's read the minutes. Thank you. Motion. Member Grills moved to state the proposal in a motion with a modification to the role of the Freedmen's Bureau, which it should say agency. Member Grills moved to state the proposal in a motion with a modification to the role of the Freedmen's Bureau to act as an oversight and monitoring body rather than as a bureaucracy, such as an external report card body on the extent to which the state is doing the implementation as needed, to provide direct resources where possible to existing community-based organizations to implement some of the tasks that are listed, while other tasks remain under the direct implementation of the Freedmen Affairs Agency. And to be quite clear, in the presentation that I just gave, right, there would still be, again, the primary functions would be for direct reparatory justice services to come directly through the agency. So that's still in the spirit of what's in the minutes. And then there would be a strategic partnerships branch that would allow for community-based organizations to be able to implement some of the tasks that are listed. And so what I just presented actually is in spirit with what you stated. I guess with the only distinction is that, no, this idea would not be for an oversight or monitoring body. It would be for a full-fledged independent agency. And again, I thought that's why the DOJ brought Chris Alamo to the discussion, because that was there still needed to be some final action around getting clarity around that today. So,
Thank you. I just want to make sure you talked it out, you make your decision and move it on the mic.
So I want to hear from the California DOJ. What was the purpose around inviting Chris Alamo?
In the last meeting, the the task force asked us to invite the Legislative Analyst Office to come talk about implementation.
Can I say something?
Yes, Member Holder, you're recognized.
Yeah. I'm looking at the meeting motions, page 23 and 24. And I'm also recollecting the discussion that we all had, which is, the presentation was similar to what we've just seen. And there was a fairly robust discussion on this issue, and there was a motion, and there was a vote. And we have a process. And I'm not sure what the purpose of revisiting that process when we exercised our democratic process and came to a decision that is recorded in the minutes. So just to be frank, I believe that we've already made this decision. And it's recorded in our minutes, and that's what I'm satisfied with what we decided in our last meeting.
So can you re-articulate, exactly what, in your opinion, was decided upon based on the minutes that we just read? And how does that differ from what I presented?
Go ahead.
So to answer in part your question, when we were presented with the Freedmen's Agency at the last meeting, there was an extensive list of duties and tasks that would be performed, and that was part of the concern that I raised, that it was quite extensive. It would be incredibly expensive to deliver, possibly taking funds away from what could be going to fund some of the other recommendations, and that it be scaled back. So when I looked at this month's version, the same tasks are still there. There's been no scaling back.
Madam Chair, I call for the question.
Question has been called. Parliamentarian Johnson.
Can I weigh in on some comments?
The call.
I call for the question.
I would like to, yeah.
They were still in discussion. However, he got the floor. He was recognized. Vice Chair Brown was recognized to call the question. The question has been called. It needs to be seconded and then voted on. There's no discussion. And if you want discussion to end, then you vote for the motion. If you want it to continue, you vote against the motion. Are you ready for the vote? On the call of the question.
Does that have to be
Second?
seconded?
She's gone.
Yes, we need a second.
Is there a second?
There's no second, then the action fails, and you
Member
continue
Tamaki,
with the
You're
discussion.
recognized.
Yeah, I don't intend to be, to delay the process. It just seems to me with the Freedmen's Agency, there are certain functions that are needed that are not being performed by any other entity. And I'm reading off basically the proposal. And then we move into other areas that are being handled by other infrastructure that I think we need to at least think about coordination with. And Chair Moore talked about working with CBOs and that kind of syncing, coordination. But to be clear, here's a listing of some things that I think would be unique to the agency. Internal audits in connection with the efficiency, economy, effectiveness, financial aspects, and I presume in connection with programs that have impact on the descendant community. The Freedmen Savings and Loan Trust Bank Service, that's unique. No other entity is doing that. The Office of Strategic Communication for Media Affairs will assist the descendant community, the media, with greater public understanding. I think something like that is needed just generally, bearing in mind we sunset as a task force. There's a genealogy branch to assist in research that's distinct. An Office of Immediate Relief to expedite claims, so claims administration not being performed, obviously, by any particular branch. Let's see. There is a providing support for descendants in the entertainment industry, including removing barriers to advancement in the arts and sports industries. I don't think there's any entity doing that. Support descendants in business licenses, recreation of cultural hubs, leisure sites. These might include watering holes that Pastor Brown, talked about. That's not covered. There's a business affairs office to provide advice on entrepreneurialism and financial literacy, providing grants, business licenses, and so on. That seems pretty distinct. Community support branch to improve accessibility, transparency, and public trust with the California Reparations Claim Program. So I think those definitely seem to me to be distinct and be a reason for a separate entity. But then there are some that I'm having trouble wrestling with. So maybe further discussion would help me. So it moves off in basically, let me just, the education branch to offer free tuition, states, community colleges, universities, eliminate barriers to higher education, provide educational grants, and otherwise support education initiatives. So on the education proposal that Pastor Brown and I were poring over, it does include a lot of that in fairly significant detail, especially how the free tuition would be done, what agencies would be involved, and more to the point, things like anti-bias training, Black Studies curriculum. I mean, there's pages basically just devoted to education, and then getting more funding into underserved communities, and we talked about the local control formula to get more money into that. And so it's a pretty elaborate structure already. So it's unclear to me how the Freedmen Affairs Agency would either work side by side or take over that function. So that raised a question to me. There's a Social Services and Family Affairs branch to identify and mitigate the ways that current and previous policies have damaged and destabilized descendant families. No question that's a need, but in the pathologizing the Black family and foster care and school discipline, I mean, we literally have pages of recommendations on how that's going to work and the different agencies involved in that, including CBOs. So it was unclear to me whether the Freedmen's Affairs branch would be a parallel infrastructure working alongside, or there would be some synthesizing integration function, which could be, participatory, could be oversight. It was unclear to me. There's a recommendation about a legal affairs branch that would coordinate free legal services and provide referrals and federal public defender and defense attorneys for criminal trials and parole hearings. So anybody in the room who's been involved in working in the public defender's office knows there's a myriad of these agencies. They're mainly county, but there's private and community-based organizations that do that. And so is this augmenting, would the Freedmen Affairs augment that, be an addition, or somehow be different or the same? There's a medical services branch that will provide environmental health technical issues. So in the health section that, again, Pastor Brown and I worked on, there's pages of environmental health ranging from, replacing lead pipes to ending food deserts to regulating the closure of public grocery stores, the fast food kind of poor nutrition available to communities. And that's all integrated with the Department of Health and existing agencies. So it's a fairly complicated structure that's already in place. So it's unclear to me how the Freedmen Affairs would take over that process. There is a section here on housing. And again, in the housing section and the advisory committee that worked on that, I read the proposals. And again, fairly complicated thing regarding CBOs and empowering them and the building of low-income housing and this sort of thing. And then the question is, how would that be different? Then there's a labor and employment branch to supervise labor and employment claims. This is more in terms of an area that I have experience with because I've done years of plaintiffs' employment discrimination and, of course, dealing with both the benefits and the problem of Department of Fair Employment and Housing. But there are lots of legal organizations. I was a poverty law attorney for many years throughout the state of California that is doing that. So again, does the Freedmen's Bureau augment that, or is there some coordination with that? And so I think these are issues that the legislature are going to ask anyway, so I'm kind of raising them now. I'm in favor of having a Freedmen's Affairs agency, especially for those things that are needed. Like you do need a claims management administration. And as far as functions that are not offered in any way now, and even by CBOs, I think this is really needed. But in those areas that basically kind of look like they duplicate not just a small part of Sanford of the budget, but the medical structure, for all its issues, is huge. It is massive in the state of California. And so to what degree is there is a syncing coordination process? And one simple way, I guess as of the January meeting, is to have input by the Freedmen's Agency, but maybe that's not sufficient. But then is the flip side of that, you create a whole duplicative parallel system. I'm not sure. So I just needed clarity on that as it's being proposed. Thanks.
Yes, it is my understanding that we don't need to reinvent the wheel with all of this specificity, bureaucratic structure, that this agency is supposed to have oversight and some teeth to make sure that things are done, and that's all. So what's wrong with that?
I voted in favor of that, but we're basically talking about a reconsideration of that vote.
So what's the problem?
And I would, like I said, I would add also the distinct functions that only the Freedmen Agency could carry out. So it's not just oversight. There are very substantive necessary functions that I see would be necessary. But as it gets into these broader, to provide medical services, that's a big undertaking. So I just wanted to get clarity on that.
Madam Chair.
One moment.
Let me exhaust it, please.
We're gonna, okay, Vice Chair Brown and then Member Jovan Scott Lewis and then Member Holder.
Why are we going around in circles on this, and it's already in the minutes? As Nika said, it's just through this agency to make sure that things are just done. Just do it.
To clarify,
all.
Vice Chair Brown, yeah, what I'm interested,
I know it's already done, so why are we arguing?
yes, go ahead, Member Jovan Scott Lewis.
Thank you, Chair Moore. It seems like a couple of things are being conflated and even confused here, which is the issue of oversight versus administration, and then the role of CBOs. And so I think what we seem to be debating is whether this agency should be covering services or have oversight over services that are provided. What Member Tamaki just laid out was that there are many, many, many areas that an agency like this is absolutely required for to be an administrative unit, right? But that there are areas that would seem duplicative of existing services. Well, meaning if we're thinking about medical services, which is what you brought up, Mr. Tamaki, that an agency like this should have oversight over those processes, but shouldn't also be responsible for administering those services. And so I think that's what it sounds like we are trying to clear up. But what the minutes, I think, propose is that there's a question of the role of CBOs in that process. And I don't think, my sense is that that's what we are actually having an issue with, right? Should CBOs be involved in this process, or should there just be, right, an agency? And I just wanted to state that because apparently maybe some things were discussed yesterday and I wasn't here. I apologize for my absence. But hearing the conversation so far, and thank you for the continued discussion, that's what I'm hearing as being the kind of point of confusion. So I think it'd be helpful if we can decide what we're actually debating. If it's the role of CBOs in this process or not, or if it's the role of the agency, right, creating wholesale services, regardless of whether those kinds of services exist or are already being provided for through the state, or if we're asking for, let's call it something of a hybrid approach, where this agency provides what we can think of as, right, unique services, right, to the community of eligibility that are not being provided whatsoever and that are actually a part of the reparations package that we're proposing. And then, right, as part of a kind of continuation of, protective services over this eligible community, has oversight over processes of existing administrative services, like medical service, for example. So I'm not stating a position on this, I'm just trying to clarify the field of conversation, because I think we are confusing a few things. Thank you, Chair Moore.
Member Holder, did you have a comment?
I think the way that Javon Scott Lewis just described it, that really deals with the situation that we're looking at. I will say that I do recollect that we did have a fairly robust discussion in the previous session, and tried to tease apart some of these issues and came to a determination, put together a motion, and voted on that motion, which is one of the reasons why I'm confused as to why we are duplicating that process when it's already been decided. And I do think that process is important. So, that's really that was really my concern. But I will also say that I think what's really great is that we are all on the same page. We all believe that a Freedmen's Bureau needs to exist. And so we don't have to grapple with that issue. And I think we all believe, and this is consistent with Dr. Brown just said, is that this Bureau should be providing oversight, and it should have teeth, it should have power, it should have things like subpoena power, so that if things are not getting done in the other agencies that already have the technical expertise to do it, if they're not being adequately done, then this agency will be the watchdog to bring it to the people, to publicize it, to get the information and the data, and to make sure it gets done. And that's where it would be great if we can have an agency that is for the descendant community, that is developing expertise in that oversight process instead of trying to develop administrative expertise in things like public defender services. I was a public defender for 6 years. That's an extremely complicated bureaucracy that it takes decades to develop expertise in. So we don't want to have like this diffuse system here where you can't develop expertise in everything. We need an oversight body that's strong and that has expertise in oversight, communications with the public, and is developing relationships within that construct instead of being all over the place. And so that's what I understood that we were voting for last time.
So based on the vote that occurred last time, so I just want to be clear. So are you saying under, the proposed agency that, went through the vote last time, that there would be no direct services provided via this proposed agency?
Can I weigh in on that?
Okay.
I think there are specific areas where there's no entity providing these services. So claims administration, for instance, or the cultural affairs part, or other really important stuff. But if the entity has to hire doctors and lawyers and recreate a medical structure, that's where I'm a little bit confused about in terms of whether that's a practical approach. So I am saying there's direct services that are needed, and maybe if this is a motion to reconsider, there would be a listing of, including but not limited to, examples of what the Freedmen's Affairs Agency would provide in direct services, and then break out areas in which it would have more oversight and responsibility, like the hospitals, clinics, this kind of thing, legal services, the other stuff that are huge. They're huge. So unless the sense of the task force is that the Freedmen's Agency should just add to what's already being done, then it is an oversight process. So there's a combination, both direct services that are unique and then oversight of these areas that are listed, like medical, legal, mental health, this sort of thing, that are already quite complicated.
So I'll just say this. So when we look through, the 105 pages of consolidated proposals, right, I went through every single one of them. And majority of them are either race-based or they're universal in nature. When you look at, for instance, the education section that you and Vice Chair Brown are tasked with, there is language around again, I brought this up in January, around the funding of the ABC program. That's to help all Black people, regardless of lineage, get into the medical profession. So it's for African Blacks, Caribbean Blacks, and African Americans. And so I thought I dissuaded that concern that there would be any duplicateness when we talk about the medical affairs branch, for instance, in this agency. It's specifically for descendants. And so again, when you look at this 105 pages of consolidated proposals, where most of them are race-based and universal, when we talk about what reparations is this type of agency where we're providing direct services to descendant community. And then also something that I wanted to bring up, we have the power to reconsider. Right? We brought in 8 experts for our implementation panel yesterday. We heard from Chris Alamo. They all had concerns around, the motion that was passed last January about the involvement of community-based organizations and the centering of community-based organizations in this type of process. Also, we've heard from the public yesterday and today on the phone lines and in person, who are advocating not simply for an oversight commission, but for a new and independent agency that will provide, reparatory justice services to the community. And so, again, it's not enough for us as 9 esteemed colleagues to determine what repair looks like. We have to listen to the descendant community. If we want to if we want to be in full accordance, with international law, which AB 3121 dictates that we do, that means we have to listen to the victim group. The victim group in this context are descendants of American slaves, are freedmen. If they're saying that they want a new independent agency that goes beyond simple oversight, that goes beyond funding community-based organizations, we have the duty to listen to that and to reconstitute. That nothing is final until it's final. The final report doesn't come out July 1. So we have the authority to reconsider any decision that we've made over the past year and a half. And that includes the motion that was, yeah, if you wanna, retry that, let's do it.
Never mind. Go ahead, finish. I'm sorry.
Madam Chair, there's such a thing as practicality. I hear what you're saying. How do you do it?
Yes.
It's like that story about Dr. Centipede. Well, Mr. Centipede and Dr. Grasshopper. Mr. Centipede had a problem with all those legs. And Dr. Grasshopper comes along and said, well, if you become a butterfly, all you have to do is flip your wings and move from limb to limb. You'll be all right. Mr. Centipede said, well, how do I become a butterfly? He said, that's a tactical, strategic question. I only talk about what ought to be done. We got to be practical and understand how you get it done. And in this society where we are still citizens, we are not a totally separate state or world. It appears to me that the sense ought to be this agency having the authority to be on top of the already established mechanism to enforce what these African Americans are deserving of as citizens of this nation. That's all.
Senator Bradford, you're recognized.
Thank you, and I deeply appreciate the discussion that's going on right now, and I totally embrace what the interim report stated, that we need a separate standalone agency, regardless of what we call it. But I also heard the Legislative Analyst's Office very clear yesterday, and it's a lot of moving parts here. And the piece that I don't hear anybody talking about is making sure that it's fully funded and it's staffed and equipped. That needs to be part of our motion as well, that it's funded and it's staffed and it's equipped to do the job necessary, whether it's working with community-based organizations or doing it internally. Because if that's left out, the devil's in the details. If it's no money to do it, you can call it what it wants. You can sign it to whatever tasks you have, but if it's no money, nothing's going to get done. So we have to make sure that it's funded and it's staffed, and that should be part of that as well. So whatever that agency is.
John Sawyer, you're recognized.
And I also think that part of this is how do we ensure that this entity, whether you want to call it a commission, whether you want to call it a department, whether you want to call it a bureau, I'm hearing that you wanted to have teeth. You wanted to be of substance. You want to make sure that whatever they do, or whether they propose, or whether they demand, it can be done. The example I will give you, in Los Angeles, there was an attempt to pull all the homeless services activities together in the 90s. They called this entity the Los Angeles Housing Services Agency, LAHSA. In their zeal to put it together, they never gave LAHSA teeth. They thought they did, but it turned out to be an entity that gathered information and told people what was wrong with the homeless population. You see where we are right now, today.
because we did not give it the teeth. It was not set up appropriately because we rushed to get it done. And although, and this is a great report that the chair put together outlining what the aspirational things that we want in this, there is a technical state bureaucracy, constitutional demands, administrative demands that are voted on that we have to, probably just the two of us, going to have to go through the minefield to try to make this happen. So clarity, unbelievable clarity, even something like how do we pay for it is really, really, really important that we establish that. Because when we go to the other side, they may come back with a number that's astronomical. And Senator Bradford and I have been through that several times where we try to do something, and then all of a sudden, everyone's talking about it's cost prohibitive. At the end of the day, we want this done. But also, how do we ensure across departmental line, because that's what's wrong with the homeless population right now. There is no one in charge. You have to have somebody in charge of what we want to move forward with. And if it's a bureau, if it's a person, if it's a cabinet commission, it's got to be somebody that's not only has the power to be able to go across departmental, be able to go across whatever budgetary demands there are, but most important is sustainable, that they just don't put someone in or start a department and then long after we're gone, that department is phased out because of budget concerns or other things. So for me, I want to make sure that when we leave this and you put it in the hands of the elected officials and the bureaucracy of the state, which you don't want, you want to make sure we're very clear about what exactly you want, because you don't want it left up to us to decide, because you're not going to get what you want. And so I think what you're hearing from several members here on the panel is clarity is really, really important. And people who've never put together a budget, never put together legislation, we need to come together with the people who have the academic or the legal expertise to come together to make sure we get exactly, and I'm keep saying that, so we can get exactly what we want, or all of this will be for naught and we'll be disappointed. And so that's what I think we're trying to get to, and I don't know if we need another month to work out the details, but we need to work out the details, because if we decide now and then a year from now you look up and someone says that's what you said here or that's what was meant here, then we'll all be, everyone, this task force and everybody out here will be unbelievably disappointed. So it's really about making sure we get what we want. Thank you.
So, Member Montgomery Stepp, you're recognized.
Thank you. So I think the comments from Member Tamaki were helpful for me, recalling our last conversation, because there was not real clarity in that motion in the last meeting. I did think that we were, even though I did not support the motion at the time, I did think that there would be further conversations with regard to line items and striking out or adding what is already in the proposal. And we did not get there, which is why I think that there is confusion. My concern has always been that with a task as daunting as this, with centuries of oppression, with a 500-page report that we have submitted to the public, we have a grave responsibility to fulfill what we need for the descendant community. And there is no system, there is no structure, there is no agency that has done that up to this point. And so that was my concern. We do have oversight boards. We do have folks that are charged with, ensuring that there's racial equity and, all of these other things. But this is what we're doing has never been done before. And so I don't want to push a lot of these policy recommendations into the current system that we have without the protection of an agency. That is why I think I've been pretty consistent about that, but if there is a proper motion and second on the floor, but if it does not pass, we have to do the work of going through, clarifying, outlining what is in the current proposal, because that is what is going to matter here. But I just don't think that we have reparations without an agency. I don't think that it's going to happen. And so we have to have an agency and as many direct services that we can provide for this particular community is important. I will say on the other side, bureaucracy is bureaucracy. It is. And there are so many things that are passed that have an intention that don't end up meeting that intention because of the bureaucracy. Partly that is lack of clarity coming out of bills, but the other part is us as a collective, as a community, not paying attention the way we need to through an entire process. This is like the beginning of what we have to do. And it's gonna be a lifelong fight. That's just, and if it is not, then the agency will go off into the sunset, just like everything else will go off into the sunset. So that is a communal responsibility that we have to do to hold people accountable that we put in these positions, whether it be us here, whether it be the governor, whether it be those that are heading up the agency. That is not going to stop. And this idea that we have that when we pass things, they're supposed to appear and do what they're supposed to do, that's just not, it's not gonna happen. There's accountability and should be accountability on every end. So bottom line, if this motion does not pass, then we really have to be specific about how we give this agency what it needs to accomplish the ultimate goal without necessarily holding back based on it being hard. I'm over that. Because what we are doing, every step of it is going to have resistance, is going to be hard, it's going to take decades. Nobody wants to hear that, but it is. And for us to be where we are right now, we have to consider the big picture. We have built out bureaucracies for everybody else. We have. And so we have to, in my mind, that's what we have to do. Understanding and having grace with each other, y'all. Look, all of us having grace with each other. We have the right to say what we believe, but I would just ask our community to stick to the facts of the situation and not attack a person personally. I'm just personally asking you that. Back to the agency. I just think that this is so important and that we do have to be specific about it. We've heard the people come in and talk about implementation. We have heard what we have to account for in this process. So I would just leave that out there in the event that this motion does not pass.
And so the last thing I'll say is this. This is a reparations task force. This is not a racial equity task force. Governor Newsom signed into law AB 3121, which established a reparations task force. That's why we're all here today. But a lot of people don't know, via an executive order, he signed for a racial equity task force. And if you read the executive order, which created that racial equity task force or commission, there's a specific section that talks about the increase of funding to community-based organizations. That type of dynamic where community-based organizations are centered, that's much more appropriate, in my opinion, for a racial equity task force. But when we're talking about reparations, again, this is me drawing from my international law legal background, you're talking about what the state owes to victims of gross human rights violations. And so centering community-based organizations in a reparatory justice framework doesn't make any sense. Also, again, I think the motion on the floor, even though I think there was some confusion, Vice Chair Brown, but in full integrity, the motion is to reconsider the vote from January because, right, the decision was ill-informed. We made a decision without significant community input, and we made a decision without input from experts, right? So we had 8 people give us expertise around the implementation of a proposed agency. You have Professor Michaels from UCLA Law that submitted to us 15 pages of how we can make a full-service agency work. We have the duty and the right to reconsider any decision that we've made. And again, I think the decision that we made last January wasn't as fully informed as it could have been. Right? We did not have any significant real community input like we had yesterday and today, and we didn't have significant expert input like we had yesterday. And so, no, I want to go back to Member Tamaki even, because I think you were trying to get towards middle ground in terms of this proposed agency. I do think that there needs to be direct services. It shouldn't only just be an oversight body. It should also provide direct services. No one tells Native Americans that the Bureau of Indian Affairs is too wonky or bureaucratic or that they don't deserve it. No one tells our immigrant family and folks that the Office of Immigrant Affairs is too wonky or bureaucratic. So why should that answer be sufficient for the descendants of slaves? Again, you have folks from Congress as early as 1865 who said there needs to be a permanent institution that provides direct services to these people, not because they're Negroes, but because they have been despoiled of their rights for centuries. Why don't we deserve direct services just like any other group of people? Tamaki, you're recognized.
Thank you. I agree with what you're saying, so no mistake about that. What I worry about is scope. And yes, it's true that there's certain departments, Bureau of Indian Affairs and Immigrant Services and this sort of thing, but they don't have their own medical system statewide. They don't have their own legal system statewide. They don't have, so I'm not against it. I just want to know the clarity on the scope. And if it's something like, yes, we're going to provide the services that are unique and not offered by anybody else, absolutely, and we're going to augment the existing services, and we're going to coordinate with those existing services. And to the extent that UC Prime, for instance, in education, is not adequately focusing on the descendant community, it is producing Black doctors. And we do know statistically, as Javon Lewis has pointed out, that Black medical providers result in better outcomes for Black people. But if that program could be changed or modified to be more focused on the descendant community, then that's a good thing. But I would say, is the answer to recreate the UC Prime, which identifies promising youth from high school and couches them in a sort of pathway program through college and into medical school? Do we recreate that for the Freedmen Affairs, or do we have influence over the way UC Prime operates and maybe modified it?
No,
I'm just asking the
yeah.
question. I'm not even advocating one thing or the other. I'm just saying that I know for sure we need the agency, no question. I know for sure there are services that are not being offered by anybody else. I just want to know on the bigger scope issues that involve big, big money and big, big bureaucracy in every city. We're talking about hospitals and clinics and schools and this sort of thing, what the scope of this is. And if the scope is it has to include everything, then, I mean, philosophically, I agree with it. I just don't know whether that's a practical approach or not. That's all I'm asking, basically.
I'll just say the Bureau of Indian Affairs does have its own education branch that implements federal Indian education programs to those who are eligible. They do have their own justice program. They have their own economic development programs. And again, the scope of the harm to the descendant community is innumerable. And so the scope of the solution has to be as big as well, if not larger. And so if we know that the state legislature is going to do what it's going to do anyway, why would we kind of go in weak in terms of the proposals that we're going to recommend? We should be as big and as bold as possible and rely on the community who is going to push the proposals that they want. And they've been saying they want a full-fledged agency that provides direct services as well as providing oversight to existing state agencies that are supposed to, assist us as well. So, again, the motion on the floor is to reconsider what we voted on essentially last January, because in my opinion, it was ill-informed. We had yet to hear from the community on the issue, and we had yet to hear from experts on the issue as well, who pretty much all cautioned against centering community-based organizations in this way, and then also provided ideas for how to create a full-fledged agency that provides direct services. And for instance, this Freedmen Affairs Education Branch, it would not duplicate, for instance, the UCABC. The only way it would duplicate what the UCABC does is if the Freedmen Affairs Education Branch provided, a medical track for African Blacks, Caribbean Blacks, and Black Americans who descend from slaves. This education branch in the proposed Freedmen Affairs Agency would just be for descendants of American slaves. So there would be no duplication.
Yeah. Thank you.
Chair Moore?
Member Scott Lewis, you recognize.
Oh, okay.
Member Tamaki.
It was me. I wasn't sure if
Member
Vice
Scott
Chair Brown
Lewis.
was talking. So it sounds as if nobody is opposed to an agency, right? And I think, and I want to just make that very clear. What we're debating is the scope of powers of that agency. And so what's on the floor really is a question of, should this agency, again, provide wholesale services, even if they are already existing, though perhaps ineffective, right? Or should the agency provide services where they currently do not exist whatsoever, and then I think have oversight function over services that do exist, right? And I think this is what Member Tamaki was getting at earlier. So that's issue one. And I think the other issue, as I said earlier, is that there is skepticism around the role of CBOs in this process. So I think what you're really trying to get at with the reintroduction or the introduction of a motion is whether we should keep CBOs or get rid of CBOs, and whether we should, or how we should, at this stage, as a motion, determine exactly what the scope of oversight or responsibility should be for the agency. But I just want to kind of state clearly that it does seem as if everybody in the task force is in agreement that there should be an agency, and that the agency would have direct responsibility for the descendant community, the eligible community that we voted on. And so I think it's fine for us to refine this process, and I think that's what Member Montgomery Sup was saying, right? The assumption was that, as we've done with all of the proposals, we'd be able to go back in and further refine what we are recommending. And so I think the question that I have to the DOJ is, can we do it that way? Or do we actually have to recreate an entire motion that gets rid of the CBOs and so forth? But I do think we're trying to answer these two questions, right? CBOs in or out?
No, that's not.
No,
that's not-
but that's in
can I
the motion,
clarify?
though. The CBOs are in the motion. No, but what I'm saying is that when I'm recognizing what the points of confusion are here, and there are 2 points of confusion. One is the role of CBOs, and the second is if this agency should just be an oversight body or if it should actually be involved in the business of providing direct services. What I understand from what has been said is that everybody agrees that there should be an agency, that there should be some role in providing direct services, but the question is, what services precisely? And so what I'm trying to figure out is, how do we answer those questions? Do we need to answer those questions through a motion, or are we answering those questions through the refining process of going through the proposals which we will vote on, right? That's my question. But I just want to make clear that everybody is in agreement that there should be an agency. And so I'm just trying to provide a little bit of clarity here, because if you want to have a new motion, that's fine, but I think we're all still waiting on exactly what, and I think, Parliamentarian Johnson was asking in the beginning, what exactly are we changing? And so the answer to her could have been, well, we are actually wanting to change the role of CBOs, or we're wanting to make, a further refinement as a motion to be voted on as far as the scope of responsibility for the agency.
Madam Chair.
Okay, so Dr. Grills, I have a question. So based on the motion that you introduced and that passed last month, what is your understanding in terms of, would this agency, as it was passed last month, would this agency be providing direct services? And if so, which ones, I guess?
So that was the work I thought the committee was going to be doing, was to go back and look at, based on the comments that were made, the scope of the work of this agency. As I was sharing out my concerns, it was that A, an agency is good and needed, yes. B, an agency has a scope that is too broad and has too many technical skills required and too much administrative baggage that would have to be addressed. That is an unnecessary use of time and money, and that the scope of the agency be more focused. Yes, there could be direct services, but not replicating direct services that are already being provided, albeit not necessarily to the quality and scale that we want. But this agency would have the teeth, would have the powers to impact agencies or entities in the state that are not fulfilling their mission to the level needed for the needs of the African American community. Lastly, there is this notion about community-based organizations is really odd to me, because they're part of our community. They are part of the descendant community. They are also how do I put it? They have been the source of support for our communities in some of our darkest times. In some of the periods of our greatest needs, they have been there. They are known and trusted by our communities. They are doing work now, serving thousands of members of our community across this state, and with data to substantiate their effectiveness. And they go beyond what existing agencies and entities in the state are doing, because they do not require or force us to subject ourselves to intervention strategies, for example, that were designed for white people and work barely for white people in certain instances. Now I'm thinking specifically social services and mental health services, and in some instances, health services. Why would we not want to reinforce the social safety net of our neighborhoods and our communities with the partnership of our community-based organizations? And in terms of this notion of community input, this is the last thing I'm going to say. The community-based organizations, she made me lose my train of thought, geez. The last thing that I'm going to say about this is that these community, having community input is important. I believe just about, if not all members of this task force received an email from what essentially reflects 40 Black-led, Black and Black service-focused organizations across the state that do want to be involved in the repair of our neighborhoods. So we have more community input than there's just in this room, and we need to also pay attention to that.
I just wanted to clarify, and then we'll go to Member Montgomery Step. The motion on the floor is, again, to reconsider the vote that occurred last month. But again, this proposed agency that's under current consideration right now, it would provide wholesale direct services to the descendant community, even if there's so-called duplication. It would also provide oversight to existing agencies. But not only that, CBOs aren't cut out of this proposed agency. If you looked at my presentation, they're just not centered in the way that we centered them in the last vote. In this proposed agency, there would be a strategic partnerships branch where the leader of the strategic partnerships branch or office would be in conversation not only with community-based organizations, but private corporations and other public or private entities to determine, how to eradicate these lingering badges and incidents of slavery that we identified in our interim report. So I just want to be clear, community-based organizations in this, proposed agency are not cut out. And so I just want to go back to Member Jovan Scott Lewis's point in trying to get some clarity, where it's either we remain, the vote remains as it was last January, which is for this agency to exist, but it's simply, an oversight body. And the majority of resources would then go to community-based organizations, as in the minutes. Or we could reconsider, in light of the community input we received yesterday and today, in light of the expertise we received from our various experts yesterday in our implementation panel, to, again, create an agency that provides wholesale direct services to the descendant community, also provide oversight to existing agencies as well. And again, within that agency, there would be a strategic partnerships branch that wouldn't necessarily center community-based organizations, but would work and collaborate with various different entities to ensure that the badges and incidents of slavery that still impact the descendant community are eradicated. And this is not going to be a 5-year project, a 10-year project. This will have to be a perpetual project. And so that's why the scope would have to be, I think, large in nature. Member Montgomery Step.
Two quick things. One is, I think for myself and for the other task force members, I think our duty is to think best case scenario, because I haven't seen a bill that has gone in the legislature that has come out in the same way. And so with us thinking about what would be the best case scenario to get the descendant community where it needs to be is, I think, where we need to start, and not already be whittling down, because more of that is going to happen as it goes through the process. I think we have another responsibility as it goes through the process to make sure that we are managing the expectations of our community, but starting at a place at a deficit is a concern to me. So I'll put that out there. And then the other part is, I really agree with Member Grills as far as the importance of our CBOs in our communities, wholeheartedly. I think the larger issue, in my opinion, is the fact that rich people get policies and poor people get programs. And the fact that this is a policy that is integrated into our system so that we don't need as many social safety nets. And that is why I think I will never disparage CBOs. I just think that the reason why we need them and we're so dependent on them in our community is because of the very thing that we're trying to eradicate through this task force. And that is an overall, I think, issue for me that I just want to clarify, because I'm not disparaging CBOs at all, and I think that the partnership still serves a role, as Professor Michael said yesterday and as the presentation says today.
Madam Chair,
Vice Chair Brown, you recognize.
let me make it plain. The language ought to indicate a hybrid program. We have hybrid cars. It takes 2 wings for an airplane to stay in the air and 2 wings for a bird to fly. So all we need to do is just put hybrid language in there and not lock ourselves in, and that will solve it.
So the hybrid language be direct services and oversight.
That's right.
Chair Moore, may we?
Direct services where needed.
That's what it. Who wants to speak from the California DOJ?
So we're both going to speak. Me substantively, Doretha's going to lay out, but I think what Dr. Brown just laid out is a synthesis of where the task force is, and that needs to be stated as a motion that modifies the previous decision, 7-2 decision. That motion needs to be, well, I'll let Doretha talk about it, but just to clarify, you'd be modifying the question, you'd be modifying the previous motion. And from the Department of Justice's perspective, you are giving us direction as to how we are drafting this in the draft, which you all will then see in draft form later in March in advance of the next meeting. And we will be executing on the task force's direction on this point moving forward. So it's really important that we get a clear motion that gives us direction as to exactly how to go. So I'm asking for that. Now, Doretha?
Thank you. You can either, I've heard reconsideration, you can either go back and reconsider and withdraw that motion, vote that motion, the earlier motion, down, and start and create a single motion that Vice Chair Brown stated with the modification based on a hybrid.
Yeah.
And that way you've got one motion, but because that first motion already deals with the community-based organization. It already has that in. But it, as I've heard, some have said that it's not as clear as you would like it to be. So if you remove that motion off the table, you have to do it as a reconsideration. The person on the, and it's a two-parter. So you would do the first part by simply stating, you move to reconsider the former motion as identified. And if you do that, that has to be a person who was on the winning side, if you would, who voted for the motion before. So that would be anyone but the 2 people who voted against it. Okay? So then after you've done that, then you vote on that motion. And when you vote on it, you need a 2/3 vote to get that motion reconsidered. And then the second part is to make the motion as a hybrid motion stating exactly what it is you want to direct DOJ to do. And if you want to say with flexibility so that they can talk with whomever they need to, then that would be a good, language, a good word to use within that. But that's up to you. If you don't want to use that, you don't they do that anyway? Yeah. Oh, you do that anyway, so, okay, so that's what I would recommend, is that if you would do a motion for reconsideration, and you want of that earlier motion made last month, and then move to rescind the motion.
I need some clarity. Because when you look at the way that the minutes are written, it does say what was passed was that this agency would be an oversight or monitoring body. But then later on in the paragraph, it says, certain tasks would be outsourced to community-based organizations, and then other tasks would be implemented, or services would be implemented by the agency. So that means that it would be dual. But when you introduced the motion, I think you were saying that it just needs to be complete, just oversight and monitoring.
No.
Chair Moore, if I could weigh in on this. I think, and again, it's important, I think, certainly from the task force perspective, that they understand what they're voting on. It's equally important that the DOJ understand so that we can execute what needs to be done. What I understood Dr. Brown to say, and what I've extrapolated from the discussion, is that this agency would provide direct services where none are being provided, and oversight of those agencies that are engaging in activities that you've identified need to be done. So it's in essence filling the gap. This agency would fill the gap of what isn't currently being provided and provide oversight for those agencies that are already providing services. If that is in fact the motion that's intended, I don't think community-based organizations are really at issue in what's being contemplated now. That would just be the direction in terms of structuring how the Bureau would operate.
That's it.
Member Montgomery Sub, you're recognized.
I know everyone's annoyed, but I would just say with those, the oversight piece, where the agency is providing oversight for other agencies that already exist, with the option of providing direct services as well. Because I just want there to be room for that.
That's the hybrid.
Does that make sense?
That's the hybrid.
That's the well, but
That's hybrid.
that's not what Attorney Brown just said. I just want a clarification.
Oh, yeah, yes, he did say that. He said that where there were not services provided, the agency would give direct services. And where there may be agency or structures, bureaucracy, that's not doing its job, it would have oversight.
With the option of providing direct services
Yes.
as well. Okay, just want to add that.
Y'all confusing this thing.
Just ask the DOJ to actually make a copy of the minute order, of the minutes from the last meeting, so that we all have a copy of that motion that we passed last time, because I actually think that it does everything that we just said, and we're going around in circles. So I think everyone should read the previous motion from the last session, because it is a hybrid motion. That's the way that it's drafted.
Yeah, but Chris Alamo yesterday made a distinction between an oversight commission and an agency. So I think what's the issue is that we're conflating the word agency. When we're talking about an agency, that's something independent, new.
That's what we should
but-
get it, the document, and look at it.
So when we're talking about an agency, we're talking about something new and independent, but an oversight body, that would have to be called an oversight body or commission. That's not an agency. That's what Chris Alamo said yesterday.
Yeah, we're going to work on putting it up on the screen so everyone can look at it. What I will say is we're going to try and we're going to get copies for everybody so we can all be looking at the same thing. In the last meeting, this question was resolved. So I just want to clarify, and what now is happening is sort of working within the lines of what was resolved in the last meeting as to where the line would be between direct implementation, because there's a component of the motion that said, while other tasks remain under the direct implementation of the Freedmen Affairs Agency. So to the extent this motion and discussion is giving the Department of Justice further clarification, if based on the chair's presentation, is the direction as to whether the agency should engage in direct implementation of services that are not being implemented by other existing agencies, which is what you heard from the Legislative Analyst's Office about, or whether you are actually seeking to reconsider the last meeting's vote that the agency should only be acting in an oversight and monitoring role rather than as a bureaucracy, which is the language of the motion last time.
But when we said we want both, when we gonna stop going around in circles on this?
So if,
It's both, not either or, both and.
correct, I think the question is, for us to be able to draft this, we can't draft it as every single item is gonna be both direct implementation and oversight by this agency. The question really that is being posed, if I may sort of recombine it, is because it was resolved in the last meeting that this would be an oversight and monitoring body rather than a bureaucracy, the question is whether now you're talking about the agency actually doing direct implementation of items that are not already being carried out by other components of state bureaucracy.
That's a sense of.
And that's what that was a discussion that Dawn presented. And Dr. Brown, how you were talking about this in terms of a clarification. Is that what you're clarifying, Dr. Brown?
Both and, two wings, hybrid.
So again, we have to take into account what the experts said yesterday, particularly Chris Alamo. So to me, it seems like the vote has to be reconsidered, not for personal reasons, but because of in light of what the experts said yesterday. If we wanted to be an oversight commission or body simply, then that just needs to be that. But we can't call it an agency. But if we want to call it an agency, that implies bureaucracy. That's what Chris Alamo said yesterday. So then the vote really it has to be reconsidered because, again, we made a decision last time that was not fully informed. It wasn't fully informed by the experts. Now that we heard from the experts, we have to have clarity. We have to reconsider the vote. So either, to me, in my opinion, it's either one, we want to call it a commission that does simply oversight, or we want an agency that provides direct services, either wholesale or in part, plus provides oversight. But if we call it an agency, that does imply bureaucracy. That's what Chris Alamo said yesterday. So it has to be reconsidered. Yes, Member Groves, you're recognized.
How were those experts selected?
Each task force member had an opportunity to provide witness recommendations for the implementation panel. Did anyone other than me provide recommendations for the implementation panel? Everyone had an equal opportunity.
Yeah.
And the legislative analyst was brought on by
know that part.
the
I'm just
California
talking about the
DOJ,
other
not myself, and that's who I'm resting on in his expertise in terms of why this vote has to be reconsidered.
Yeah, I'm just trying to understand, because I have to say, my observation of the testimony yesterday was that it slanted in a particular direction. I didn't hear a variety of opinions. And so that made me wonder about the selection of the experts, because you're emphasizing how critical their testimony is. It's making me wonder about that.
Everyone had an equal opportunity to provide witness recommendations. I don't know what to say about that.
Anyway, it looks like it's up. It looks like the DOJ was able to put the language up.
So yeah, what's up on the screen is the motion that was made and passed in the last meeting.
Would you read out so everyone understands, please?
Absolutely. Do you want to read it? Okay, I can read it. Member Grills moved to state the proposal in a motion with a modification to the role of the Freedmen's Bureau to act as an oversight and monitoring body rather than as a bureaucracy, such as an external report card body on the extent to which the state is doing the implementation as needed, to provide direct resources where possible to existing community-based organizations to implement some of the tasks that are listed, while other tasks remain under the direct implementation of the Freedmen Affairs Agency. Member Bradford seconded the motion. Chair Moore called for a discussion. Do you want me to keep reading?
You can
That's
read
it.
yeah.
Well, what else is there, Madam Chair?
Because there's
What are the
conflation in the language. There's a conflation in the language that was ill-informed. Now that we heard from Chris Alamo, I didn't personally invite Chris Alamo. I think Senator Bradford or the California DOJ invited Chris Alamo. I'm not resting on the expert witnesses that I personally invited. I'm just talking about what Chris Alamo said as a nonpartisan policy analyst. Yesterday, he made two distinctions. And he explained the different pathways for implementing the two different pathways or options that we have before us. An oversight commission or an agency. That would imply a level of bureaucracy. The vote that happened last January, there was conflation. So in the vote last January, there's language that would imply oversight and direct services. So that means that we need to reconsider the vote and vote for an agency instead of, we need to reconsider the vote and consider an agency that would either, and then that's where the contention is, provide wholesale services or just services that don't presently exist. But again, Chris Alamo talked about there's two different pathways, just simply a monitoring body or a full-fledged agency. That's the two options that we have before us. And I don't think that the vote that happened last January I don't think the vote that happened last January, I stand corrected, but I don't think the vote that happened last January, I think it conflates.
Madam Chair, the sentiment that's around this dais now is a hybrid. So why are we still going around in circles on this?
So we need to vote to rescind the vote that happened last January and then create a new motion that would create not just an oversight or monitoring body, but an agency that has the capabilities to do oversight and direct services. It's not me being nitpicky, but language matters.
Madam Chair, you can either.
I move that we rescind what was done before, and that we would vote for a hybrid
Go ahead.
agency, a hybrid
No,
agency.
what did you say the first?
That we rescind what was voted before.
Just withdraw your motion. Just withdraw it. It hasn't been voted on. So you don't, if you withdraw it and the seconder withdraws, then you don't have anything on the floor.
No, he's talking about rescinding his motion.
Oh, you're rescinding the first?
Yes.
Oh, I'm sorry, I thought you meant the one that we're dealing with now. Okay,
No, I'm rescinding the first one.
thank you. I'm sorry, Carrie, see the motion. Go ahead, Madam Chair. You need a second.
Is there a second?
Oh, my gosh. Madam Chair, let me back up. I was right. You have to deal with there's a current pending motion. And so you do have to withdraw that motion and take it off the table.
I withdraw it.
And it's a seconder agreeing to withdraw their second.
Yes, I agree.
Okay, so with that having been done and said, now you have the motion that you just made. And Madam Chair, I turn it back to you. He made a motion and that motion was seconded. No, it has not been seconded.
So, okay, let's just
Okay,
get some
let's
clarity.
start over.
So
He made a
need to-
motion to rescind the motion that was made last month.
Oh, so that's what we're doing.
Yes, and now you need a second from that.
Motion that was on the floor presently. So there was a motion that's on the floor presently.
It's been withdrawn.
It's been withdrawn.
It's been withdrawn. So now he just moved to rescind the vote that just
Right.
happened in January. What, is there a second? Okay, so it's been properly moved and by Vice.
No, she cannot second it. Was that Member Member Montgomery? Yes, we need someone who was in favor of that first motion.
So do you want to just read the rule?
Yes, it would have to be Grills, Member Grills, Holder.
Senator Bradford just seconded. He was in part of the 7 vote. So it has been properly moved by Vice Chair Brown and properly seconded by Senator Bradford that the task force rescind the vote that was made this previous January. Is there any discussion on the matter?
Call for the question.
Hearing no further discussion, I'll turn to Parliamentarian Johnson so that a roll call vote can be established.
Okay, the motion before us is to rescind the motion made in January, this action taken in January. Pardon me?
At the last meeting.
At the last meeting. There's a 2/3 vote that is required to pass. I will start with the chair.
Aye.
Chair votes aye. Vice Chair Brown?
Aye.
Vice Chair Brown votes aye. Member Bradford? Member Bradford? You're not voting?
At this point, no.
Not voting, thank you. Member Grills?
No,
Nay?
nay.
Member Grills votes nay. Member Holder?
Nay.
Nay. Member Holder votes nay. Member Jones Sawyer?
Not voting.
Member Jones Sawyer not voting. Member Lewis?
Aye.
Member Lewis votes aye. Member Montgomery Steppe? Aye. Member Montgomery Steppe votes aye. Member Tamaki? Aye. Member Tamaki votes aye. Madam Chair, there were 9 members present, 7 voting. There were 5 voting aye or yes, and there were 2 voting nay.
There was 6 voting aye, right? That's what I counted,
And-
not 5.
Not voting, there were.
I counted 6 voting aye, not 5. Can you please correct that?
Let me read over the ayes. I have Chair Moore voting aye, Vice Chair Brown voting aye, Member Lewis voting aye, Member Montgomery Steppe voting aye, and Member Tamaki voting aye. I have 5 voting aye. Do you have 5 voting aye? Okay. And I have not voting, Member Bradford and Member Jones Sawyer. And I have voting no, Member Grills and Member Holder. You need 6 votes to pass, to rescind the motion. So the motion fails. So your option then, that motion stays in place. You can still amend it. That's sitting there. You can amend the motion and insert what will make it a hybrid motion and accomplish the same thing that you wanted, that some of you wanted to accomplish. So you can move to do that, and then that would have to be voted on.
May I ask, would this be acceptable to most folks if we did make an amendment? And I'll even make an amendment, since I made the motion, that is kind of in line with what Damon, I can't pull up your last name, so I'm sorry. Brown suggested, something to the effect of that this agency would provide services where none are provided, and oversight for agencies where services are being provided, with the option to provide direct services being retained, period. It's basically a restatement of what.
Is that a motion?
Just being a little bit more precise.
Is that a motion?
I would like to make that motion if, okay.
It's a motion now.
Okay.
Yeah, she could make a motion.
I want to second it.
So it has been, can you please restate it, just so I'm clear?
That the agency would provide services where none are provided, and oversight for agencies where services are being provided, with the option to retain the right to provide direct services where necessary.
So, okay, so is there, okay, there's a second. It's been properly moved by Member Grills and then properly seconded by Senator Bradford. Okay, in terms of discussion, this is where I need clarity. So, under this proposed motion, that means that this proposed agency would not simply be a monitoring body. So thus, it wouldn't be an oversight commission, as Chris Alamo stated. It would be, in the alternative, an agency that would imply a certain level of bureaucracy that you spoke against last January. So again, there needs to be a distinction made between an oversight body and commission or an agency that would provide direct services and oversight.
As I started the motion, it started with the agency. So I'm saying it is an agency, yes.
So there will be bureaucracy because the
Yes, but the whole point, again, was because I don't like words being put in my mouth. There was the scope of the agency was the concern. And so now, you know, with this languaging, there is some flexibility to address the scope, recognizing where there is not we don't need to duplicate effort, but we need to make sure no matter where the effort is coming from, there's some accountability that it is appropriately meeting the needs of our community.
Okay, great. But I just want to be clear. In the minutes, it said that this bureau would act as an oversight and monitoring body rather than a bureaucracy.
I'm saying today, the agency.
We'll have hybrid.
Yes.
Okay, any discussion on the matter?
Can we vote?
I guess, so my question, we can move on, is around, again, the role of community-based organizations. In the proposal that I made, there will be a strategic partnerships branch that would not only work with or collaborate with community-based organizations, but public entities, private entities, and the like. And so I'm just trying to figure out, where does that lie in this motion or proposal? Are we still just centering community-based organizations?
Part of the hybrid proposal?
There-
Part of the hybrid.
That's part of the hybrid proposal, being able to either directly engage in services or use outside entities to deliver.
Did Mike?
All right. Any other further discussion on the matter? Yes.
May I call for the question?
Please, thank you.
Is there a second?
Second.
Okay, so we'll now turn to Parliamentarian Johnson.
To call the question, I will begin with Madam Chair.
Aye.
Madam Chair votes aye. Vice Chair Brown? Aye. Vice Chair Brown votes aye. Member Bradford? Aye. Member Bradford votes aye. Member Grills?
Aye.
Member Grills votes aye. Member Holder?
Aye.
Member Holder votes aye. Member Jones Sawyer?
Aye.
Member Jones Sawyer votes aye. Member Lewis?
Aye.
Member Lewis votes aye. Member Montgomery Steppe?
Aye.
Member Montgomery Steppe votes aye. Member Tamaki? Aye. Member Tamaki votes aye. Madam Chair, excuse me, there were 9 members present and voting. There were 9 ayes, 0 nays, and 0 not voting or abstentions.
Great. So now we'll turn to the vote to vote
We will now
on the
go to
motion at hand.
motion
Yeah.
On the floor. I will start with Madam Chair. Madam Chair?
What are we voting on?
Pardon me?
What Cheryl said?
For clarity, I just want to make sure the California DOJ is, can the California DOJ restate the motion that Dr. Grills made, just so we're all clear?
We're voting on Dr. Grill's amendment of her original motion that passed in the last meeting, which addresses what the discussion has been, that the new agency would. You just voted on call for the question.
Yes.
Yeah. And this is not an amendment because this is a new motion. Okay? So this is the motion that Member Grills made.
So is the California DOJ clear on the motion that Grills made? And please restate it, California DOJ.
So as we understand the motion, it's direction, essentially we're taking a direction to the California DOJ in our drafting of the draft report that this new agency will carry out direct implementation of items that are not already carried out by other agencies, engage in oversight of actions that are covered, that are handled in direct implementation by other agencies, and then pursuant to the motion that was made everything else in the motion that was made last time remains in terms of community-based organizations and other issues. That is my understanding of Cheryl's motion.
I would ask Dr. Grills if, I'm sorry, Member Grills, if that correctly restates the motion.
Yeah, I think the only piece that was left out was that the option to provide direct services where necessary. So,
You restated in whole, because this is very important. We don't want a repeat of what happened last meeting, where we just have this runaround conversation. So restate the motion in whole, please.
the agency will provide services where none are provided and oversight for agencies where services are being provided, retaining the option to provide direct services where necessary.
Okay, the California DOJ is clear on that?
Yes, yes. And yeah, we're clear. Are you asking if we're calling the vote, or or we're clear on the direction? We are.
Yes.
Okay, so now we'll turn to Parliamentarian Johnson for a roll call vote.
Call Chair Moore.
Aye.
Chair Moore votes aye. Vice Chair Brown.
Aye.
Vice Chair Brown votes aye. Member Bradford. Aye. Member Bradford votes aye. Member Grills.
Aye.
Member Grills votes aye. Member Holder.
Aye.
Member Holder votes aye. Member Jones Sawyer.
Aye.
Member Jones Sawyer votes aye. Member Lewis.
Aye.
Member Lewis votes aye. Member Montgomery Stepp.
Aye.
Member Montgomery Stepp votes aye. Member Tamaki. Aye. Member Tamaki votes aye. Madam Chair, there were 9 members present and voting. There were 9 ayes, 0 nays, and 0 abstentions or not voting.
Great. Thank you so much. There are 9 ayes, 0 nays, and thus the ayes have it. So this proposed entity would not simply be an oversight or monitoring body, but it would be an agency, independent agency that would provide services where they don't presently exist, provide oversight to existing state agencies, and then there would leave the option for additional providing of direct services. So I just want to be clear in terms of the nonpartisan policy analysts, who I did not personally invite, who made a distinction between the oversight body and commission versus an independent agency. And the vote that just passed was not to create simply or just an oversight commission, but a new independent agency, correct?
That's right, Chair Moore.
All right, we're clear then. All right, thank you so much. Okay, so the next item on the agenda is the next advisory committee.
No, Chair Moore, just to clarify where we are on the agenda, we actually, I think the presentation that you gave was at the beginning of what was agenda item 19, which was actually supposed to be before lunch. We have a number of questions for clarification for the final report, and I think rather than proceeding advisory committee by advisory committee, if you'll reflect back on the first report, we are now at the point where the task force as a whole is going to need to analyze the report as a whole. We're sort of past the advisory committee portion. All the advisory committees have been incredibly helpful to the Department of Justice to develop and flesh out all of the different proposals. Those proposals have now been presented. Each of you have a hard copy in front of you of outlines for the final report. Our intent was to go through the outlines, given the time that we just took up on the agency issue. I think what I would request is that we outline a number of questions we have for the task force as a whole in terms of the final proposals, so that we can get direction on items that we need direction from you all as a group to inform our drafting for the final for the draft report that's going to be presented to you at the next meeting. Just in terms of the lateness of the hour, I think that'll be a more efficient way to go through these. Okay. And some of these are pretty meaty components. Oh, we're not yet to the organization. So first is eligibility categories. We have noticed, some of this is just making you aware of things we're noticing as we're drafting, and others are decision points. We have noted that some policies that have been developed by various advisory committees are universal, such as elimination of the death penalty or raising the minimum wage. Several are focused on descendants specifically, and several focus on the Black community even more generally than descendants. We also have a definitional issue in some of the components, such as how the Black community is identified, or how we approach when talking about different subcomponents, not only the community of individuals, but a geographic community. So that applies to neighborhoods and schools. So questions that we have for this task force, part of it will be things that you'll see when you're reviewing the draft that you'll get next week, is a recognition of an approach that takes into account the varying application of the different components. So some components are going to apply more generally and some are going to apply more narrowly. We want to raise that to your awareness so that you see that you understand the background of where those are falling and why, and get your input as to any particular parameters you all want us to follow in resolving those issues. Similarly, we had an issue in the interim report regarding the resolution of the question of Black versus African American. We resolved that issue by going with whatever the statute, as well as if we were referring to programs or scholarship that was using that terminology, we sort of held firm to that scholarship. So we used both terms. We want to make sure that the task force is okay with that same approach in this report. Again, alerting you to the fact that you'll see the draft, and so people are really concerned about those specific terms, raising to those to us when you see the draft.
Visual, or is that in the meeting materials in terms of what you just described?
Well, a number of people have raised it to us, and I'm raising it to you now. It's not a specific slide or anything like that. It's just general concerns with the final draft.
So just summarize the concern again. Just summarize what you just said, please.
Are there any specific directions that you have with regard to terminology or considering that? It's really actually not an item to vote on at this time. I think it's more making you aware that there are going to be differences depending on the different components of the report, and see if anybody has any concerns or issues with that or direction as to their advisory committee, how you've approached it in different items.
Well, I'll just say the statute that created this task force, AB 3121, I gave a presentation on the statutory provisions last March, right, in terms of it describing the closed universe of those who are eligible, stated freed African slaves and their descendants. The statute described freed African slaves as those who were emancipated via the 13th Amendment, and then described their descendants as those who became citizens via the 14th Amendment. Then on top of that, in March of last year, we essentially voted via a 5-4 decision to codify essentially what's in the statute in terms of our decision to go with a lineage-based proposal. In verbatim, the proposal or motion that passed was, you're eligible if you're a descendant of an African-American or free enslaved or free Black person living in the United States prior to 1900. And so to express my concerns, or in terms of what needs to be in the final report, in terms of the beneficiary class, I think for all of the proposals, not just from my advisory committee, we need to do our due diligence to ensure the beneficiary class for each and every proposal is in full and perfect alignment with the beneficiary class as described in the statute and as was codified by the task force last March. So that might be looking like some finding and replacing. So instead of just Black, it needs to be very clear in terms of who's eligible. And that is, African Americans who are descendants of persons enslaved in the United States, or using exactly the language that was passed via the lineage motion.
I guess we take that under advisement. So when we're directly talking about beneficiary classes and some of these proposals that can be narrowed to that, you're suggesting we narrow it to that. And you'll see in the draft report where there are modifications of that. There's why that will be noted as such.
Exactly. And then one of our expert witnesses, Margaret Fortune, spoke to the fact that California has become a don't say black state. So we also have to take into account the political climate. You have the statute that essentially is lineage-based. You have the 5-4 vote in March that was lineage-based. The political climate in this state, is that race-based proposals are inherently suspect. And so we have to take all of that in consideration. There really shouldn't even be really a debate at this point. So yes, that is my perspective, that all of these proposals need to be updated to ensure that it aligns with what's in the statute and what the task force voted on in March of last year.
Okay, I think what I'm hearing from you is we should be race conscious in the crafting of the report so that we're adhering closely to what is included in the statute itself, being race conscious, speaking about race, and having our proposals and suggestions related to race with the understanding that the eventual in statutes that are proposed may take into account Prop 209, but the report itself will be written to be cognizant of race and not necessarily limited to.
No, that's not what I said, because African Americans who descend from slaves, our race is black, but everything needs to be lineage-based, lineage-specific. That's what the statute is. The statute is lineage-based. The statute is lineage-specific. We codified the lineage-based statute last year via our motion. And so all the proposals in terms of the beneficiary class need to be lineage-specific, not race-conscious. Yeah. They need to be race-neutral, essentially. Not race conscious. It needs to be race neutral.
So to give you a concrete example, there's examples of eliminating the death penalty. There are examples of raising the minimum wage, where we went through the drafting, and if we raise the minimum wage for descendants, that means employers will have an incentive to not hire them because they will be paid more than people who do not have an elevated minimum wage. So it would actually hurt the beneficiary class. So I think that's really what I'm trying to get this discussion going and direction to the DOJ as to exactly what the task force's direction is with regard to the framing in the report. If the concern is not having a race conscious framing because of the statutes, I think that's a different question in terms of what the report, according to AB 3121, is intended to take into account in the language of the statute. So I'm trying to get direction on that point that we can then apply throughout the report.
Madam Chair, the point is simply put. The language is used consistently to be persons who are lineage-based. Period. That's all.
I think this might be, I'll just say in brief, I think Marilyn Van alluded to it, and I was going to actually say when we talk about the outline of the final report, I was going to suggest that there be an addition in terms of the discussion around, this might sound off base, but it's very related, as what Marilyn Van just stated, a discussion around tribal law, so that we can draw the parallels between, for instance, Indians, federally recognized tribes as not a race or ethnicity, but a political class or status, and making that same type of argument for those who are descendants of slaves in this country. that we're not necessarily, it's not a race, because not all Black people will be eligible. It's not an ethnicity per se, but a political status of being an American freedman, drawing on the legislative history in this country we can draw on, again, the enactment of the Freedmen's Bureau, the Freedmen's Bank, the legislative history as to how that came to be, again, drawing on from folks in the legislature at that time that said we need, special consideration and benefits for this group of people, not because they're Negroes, not because they're Black, but because they belong to a political class of folks who have been despoiled their rights. And you had Marilyn Vann, I didn't see her presentation in advance, who essentially made the same argument that just like Indian freedmen, right, those who were once enslaved by the 5 Africans who were once enslaved by the 5 civilized tribes, right? They are considered Indian freedmen. African Americans who were once enslaved by Europeans, we're considered American freedmen. That's a political class that we could have a whole section in the report really articulating that reasoning. And so I think that would alleviate any concerns around when we update these proposals and make sure that they're lineage-based, or they say descendants all throughout, there will be a section in the report that educates folks around why using the term descendant is not race conscious, it's actually race neutral. It fits into this idea that descendants of American slaves is a political class, not a race or even ethnicity. It's super advanced, but this is the time to really get that scholarship into the report, and I'm happy to follow up with you all on that later. But I do think that we need to update the language to make sure all the proposals are descendants or lineage based, and then do that extra work and care to put in a section in the report where we talk about, descendants not being a race per se or even ethnicity per se, but something entirely different, which justifies the need for descendant-based policies that would not, as Erwin Chemerinsky said, the UC Berkeley Law School dean, would not violate the Equal Protection Clause under the 14th Amendment or Proposition 209.
I have a question, Chair Moore, and really this is more so for the task force. As Michael indicated earlier, these proposals were put together by various advisory groups from all members of the task force. I think the question is, and he gave 2 examples of repealing the death penalty and increasing the minimum wage. Is it the consensus of the task force that these proposals would be framed to only apply to the beneficiary class, meaning that your report would state that you want the legislature to repeal the death penalty only for descendants of slaves, because the way that they're currently written, they're written without any modification. They're not specific to that class. Others are, but some of them that are more broad are not. And so that's part of the direction, is that we wanted to know, particularly from those who made those recommendations, did you intend for it to be applicable generally or only specific to the beneficiary class? That's the first question I had.
I made a universal policy, so that question also applies to me. So I understand what you're saying. There's race-based proposals and there's universal policies. So to clarify, there's some proposals in there that say, we need to give this to Black folks. That's a race-based proposal. Then there's universal policies that, for instance, that you said, abolish the death penalty. So, okay, I understand the question now. The question that's on the table is, I think it's clear that where there is race, but I could be corrected, where there is race-based proposals, where it says Black this or Black that, we need to update and change that so that it says descendants, full stop. But when it says universal, the question is, do we keep the universal policies that are there universal, or do we also update that language to make sure that it's descendant-based? I'll let other folks speak, but I am not opposed to having universal policies like abolishing the death penalty in the report. But if we do have universal policies in the report, I think we need to make clear, maybe via footnote or something, that universal policies are not reparations. It's just in the spirit that when African Americans do justice work, we tend to do justice work for everyone. Member Tamaki, you're recognized.
So there's some categories of repair that are clearly descendant-oriented. You can identify the injured class. So free tuition, tax exemption, I don't know, compensation. The harm class is the descendant class. You could very neatly actually do that. There are other areas that we don't categorize them as repairs compensation, but they have to do with stopping the harm, guarantees of non-repetition. And they may or may not neatly fall into descendant versus non-descendant classes, minimum wage, death penalty. I think that's right. I think, I'm looking for a sort of compromise here without compromising principle, but more clarifying paragraphs that basically say where possible, the descendant class it will focus on special emphasis and provide repairs where possible. But there are some categories, for instance, in healthcare that Pastor Brown and I dealt with, or education, which are difficult. The fact that Black people are dying younger than the rest of the population, the fact that Black women suffer from complications from childbirth and pregnancy more than anybody else, the higher rate of Black infant mortality. So if we say to the legislature, we only want you to concentrate on the descendant class, that's kind of hard to do. I mean, how do you do that? And why? Because this is the product of systems, right? Systems of exclusion. They have to do with basic things like access to medical care and not having enough Black medical providers and this sort of thing. I think a prefatory category is appropriate. Like, for instance, UC Prime, to the extent that it could focus more directly on the descendant class. I think that's within our purview, and that's reasonable and doable. But there are other harms, policing, another one, profiling, racial stops, where police basically are stopping people without knowing whether they're a Black immigrant or descendant class. But it does fall into, I think, our what we need to do, because it has to do with guarantees of non-repetition. So what I'm saying is I agree with you about the emphasis part. There are clearly those categories where the find and replace kind of thing might work. But I think we need to build in some flexibility for the DOJ in framing these other areas that are not so neatly solved by tracing lineage, but have to do with, these broader issues.
I know, it just seems like we're going backwards because, this is a quick aside, but remember, can you explain, for instance, if we're just looking at the ABC LEAD program, which again helps to get all Black folks, African Blacks, Caribbean Blacks, African Americans into the medical profession. How is that proposal not outside of the scope of the statute, that is AB 3121, and outside of the motion that we adopted last March for lineage?
I'll make a comment, and then I'll defer to other task force members. Some of the policies we're looking at need to be augmented, changed, modified, and maybe new policies that focus in on the descendant class put in place. And so it's an example of something going on right now. Is it enough, or should it be different? I give you that. And in keeping with our mission and what we voted on in March of 2022, I think that's right. I think some of these policies are trying to deal with multiple problems at the same time. Certainly one is getting Black students in the pipeline to become medical providers. That's one bucket. And for those students, emphasizing the descendant class makes a lot of sense to me. But another bucket is just getting Black medical providers out there delivering services to the Black community, because the statistics show that patients have a better outcome with Black physicians, which there are not enough of. So I could see basically, are making recommendations that augment the UC Prime ABC program or modifying it. I don't see that as directly adverse, and I also see it as something that falls within our mission.
Madam Chair. We got to look at my information. The patient who is sick and at the point of death is Black folk. We know about all this technical language about making sure we talk about letters to deal with the legal system. I think we have to stop somewhere and focus, and going universal is not going to get it. We got to bite this thing one piece at a time, and got to focus. And it's about us in the hood. We need to grab up every person that we know gives representation, mirrors Atlanta's rule, and get them into medical school. Start getting them more conscious of science, math, and medicine. We got to brighten the corner where we are. We can't be all over the place if we're gonna take care of the patient.
So are you proposing that the universal policies be changed to make them descendant specific? Is that what you're?
Some of them, yeah, I guess if you're asking me, are you asking me?
Oh, yeah.
Yeah, I think some are more amenable to that, and maybe we need clarity. But there's other categories where, as a practical matter, again, if there's a way to do this that I'm not picking up on, I'd love to stand corrected. But in some of these areas, like getting more money into underserved schools, and trying to basically, as Margaret Fortune was talking about, Dr. Fortune, about pushing formulas and policies that actually do that. At one point, she was talking about a $300 million figure that, if it was signed by the governor, could have been $500 million. That has to do basically with the formula for how that's calculated. And it doesn't necessarily say, draw a distinction on lineage. That's all I'm saying. So it seems to me we could have that too, in addition to having the special emphasis part. And I would be all for the proposal. I mean, every chapter beginning with a prefatory statement of emphasis, I think that's makes sense to me. And then also basically make it direct where it can be done, you know.
That's fine.
Letter specific.
So just so I'm hearing, so I think Member Tamaki is proposing a prefatory statement in front of each of the different chapters for recommendations that state that essentially special consideration should be made to descendants, but that doesn't necessarily change the language of the proposal itself. It's just a prefatory statement, which I think it's okay, but.
For some of the areas, maybe not. Like healthcare, I'm struggling with how you put a lineage screen on, better outcomes for the Black community. I don't know how.
Freedmen hospitals used to exist in this country, and now we're saying that they can't exist in the 21st century. Oh, sorry.
Oh, okay, well.
All right, so let's just be clear. Okay, so actually, like Member Tamaki's idea, I just want to be clear on that. And the statement that I was making, Joan Sawyer, was about the conversation at the last item where we pretty much, anyway, but. So Member Tamaki, you're stating to have a prefatory statement in front of each chapter that states wherever possible to provide special consideration to the different, to the descendant community. Vice Chair Brown, what are you saying, just to be clear? Are you in agreement with this prefatory statement, or?
We gotta be focused. And we're not going for this universal bit. It's gonna confuse it.
So
We're talking about these descendants who have been harmed, and we've already established that. I don't see us needing to change it.
So you're saying essentially no prefatory statement, but to update all the language to make every single thing descendant specific.
Yes.
Chair Moore?
Scott Lewis, you're recognized.
Thank you. So a question to the DOJ, I think. So, so we're asked to determine the eligible community. I mean, so where in the final report, I'd assume that somewhere in there we need to state explicitly the community of eligibility. Are we planning to do that? I mean, and the rationale for the community of eligibility, these things, I mean, how is that component, which is a required component based upon the bill, being conveyed in the final report?
So there's two components of this. One is the reparations, which is we're going to get to the organization and formatting of that report, which is its own chapter that talks about actual reparations, compensations, things like that. That's what the economics experts are working on, and that is the sort of key core eligibility question. And then we have all of these policy proposals that are set forth in other chapters. We'll turn to this in a second, and it may help to maybe go through the organization. You can see that. But each of these are a variety of different harms-based policy proposals, a variety of different policy proposals on different issues that, again, wouldn't necessarily naturally boil down to either race or descendancy status. And so that is the question. The different advisory committees, like Damon mentioned, came up with different solutions.
Right.
We are drafting, and we need your direction in the draft so that when you see the draft, you will be able to see that your direction has been carried out. So that's what we're really looking for, is direction from this task force.
Okay. I mean, so I understood that in terms of the conversation that has been going on. I think my question was, is there an expectation for the final report to lay out explicitly the community of eligibility and provide a rationale for the community of eligibility? The reason why I'm asking is because if we do that, then effectively we are stating for whom all of the policies have been devised and and directed towards. So I'm just trying to get, because so early on we made a lot of decisions, you know what I mean? So we've been talking about residency and so forth, and so I'm just trying to understand exactly where these decisions are going to be reflected and how, because I'm trying to think if there's a way to streamline, this discussion in a way, and this is, I think, building off of what Member Tamaki is suggesting, where there's a statement that directly asserts, who we're talking about. But the point is that AB 3121 from the beginning asked us to decide who we're talking about, and we decided that actually a year ago, wasn't it? Yeah. So I'm just asking if the report is going to account for that decision and how, because that might actually help clarify things as we go through the policies.
Yes. I think to inform this, it may make sense to go to the next agenda item.
Okay.
And then come back and revisit this.
All right,
because
that's fine.
The next agenda item talks about the organization of the report and talks about how we talk about community of eligibility and harms-based versus non-harms-based.
Right.
For classification. So we can run through that presentation. That's the presentation that's up right now.
And so just, for some background, the reason why I'm saying that is that what we do know, we have to be very honest about recognizing this, is that there are multiple terms, right, that are in circulation, even amongst the community of eligibility as to how they define themselves. Sitting here on the task force for nearly the past 2 years, I've heard some members of the eligible community advocate for being called Black American, some advocate for being called African American, some advocating for being called freedmen, some, right? So there are lots of terms. And so in many ways, all of these terms kind of show up in different chapters in different ways. And unless you all can decide, well, you see what I mean? So, and so we can't define, we can't call you, right? That's not our job. But what we can do and what we have been asked to do is decide who the eligible community is, right? And it's a class-based designation, and so I think if we can clarify that up front, then it helps to kind of make sense of some of the kind of traveling language that shows up later on in the report. That's why I'm asking if we can make a declarative statement, so that way we understand, why, or rather not why, but who we're talking about, regardless of what kinds of terms are showing up throughout the report.
Montgomery Sup, you're recognized.
Thank you. Yeah, I definitely agree with that, and to the extent that we are using the different terms in the report, because I know we use different terms in the interim report, because there are different studies that use different terms as well, that we should be clear about why we're using the terms that we're using throughout the report. I agree that it's hard for us to define, but we do have our eligibility motion. And so, and what we have a record to show what we meant by that, and I think it has to be clear in the report.
Yeah, I mean, we heard from Maureen Simmons, who worked with Secretary Weber when this was in the bill stage, and she spoke to the spirit, everything needs to be lineage specific. I guess the question is just, how do we do it? How do we do it? We can go to the next item.
Okay, so why don't we go to the presentation? I'll call out next slide. So the next agenda item, technically, we're on agenda item 22, is a proposed overall organization. Our proposed overall organization is based on, and this includes the entire work of the task force from the beginning to the end. We're going to have an updated executive summary, and there that may be a space for us to include sort of the discussion that we're just having right now. Part 2 is the interim report chapters. And by the way, to be clear, this is a proposal we're going to ask you to vote on so that we can confirm this and move forward at the end of the discussion. So there will be a vote at the end of this, hopefully. Part 2 are the interim report chapters, which will remain exactly as they were in the interim report, with the interim or preliminary recommendations stripped out, because those are obviously now replaced by final recommendations. Part 3 is the International Reparations Framework, an example of other reparations schemes, and you have in front of you a hard copy of the outline of that section of the report. Part 4 is how the state of California will offer a formal apology on behalf of the people of California for the perpetration of gross human rights violations and crimes against humanity on African slaves and their descendants. And in light of the vote earlier today, it's a vote, right? They voted. That is going to be a consolidation of anywhere there are apologies anywhere else, as well as a recognition of racist political leaders in California's past. Part 5, economic expert analysis and final recommendation of the task force regarding calculations of reparations and forms of compensation and restitution. So that's going to be the part about money and other types of reparatory reimbursement. You can go to the next slide. Part 6 are the policy recommendations to the legislature, which is the bulk of the work that's been going on right now by the various advisory committees. Part 7 is the report on the Racial Justice Act implementation, which you heard a little bit about yesterday, the survey that was conducted by the Research Center that feeds into recommendations on Racial Justice Act issues. Part 8 is the Bunch Center report on community engagement and input through community listening sessions. This is, when we were in Los Angeles, we got a report on the community listening sessions, the findings and everything else that was consolidated into a formal report, which will be, we are proposing to have sort of republished as Part 8. Part 9, not Chapter 9, but Part 9. This is a concept or themes for curriculum built around the task force's report and other recommendations for educating the public. We heard a little bit about that earlier today. And then Part 10 or appendix, compendium of statutes and case law that contributed to an unjust legal system. And this is sort of additional evidence that supports the recommendations in the unjust legal system chapter. And that can be either one. You can go next slide. We can go through this because we're short on time. Keep going through. Okay, stop there. Wait, go back. Oh no, next one. So just as a note, how the state of California will offer a formal apology, so we will be drafting that and looking for recommendations on an apology in the next meeting. Next slide. In this slide, in this discussion, I just want to highlight to the point that we were just talking about before, which is eligibility, non-eligibility, the vote on lineage-based eligibility goes to the compensation that's awarded, and then there are other issues of other forms of rehabilitation or restitution that would be harms-based. So people who actually were dispossessed of their property or lost their homes or were kicked, lost their jobs or other types of things that fall into harms-based eligibility as either in addition to or without a lineage-based linkage. That's going to be part of the economic experts analysis that's going to be presented to you for you all to vote on whether to adopt in the next meeting. Next slide. So policy recommendations, these are, I'm just going to go through these quickly, but these are the policy recommendations, and you have also, by the way, this organizational chapter on paper in front of you as well, and these are also included in the meeting materials for everybody. So we can run through Part 6. Next slide. These are all of the policy recommendations which you have already voted on to advance. There's a couple of modifications, but you'll see those in the draft. Next slide. Next slide. You'll note where it says formal apology. So according to this morning's vote, those are going to be reconsolidated into the apology chapter. Next slide. Next slide. Next slide. Next slide. We can go to Part 7. Oh, back up. So this is a report on the Racial Justice Act implementation, and we are still working through this with our experts in the DOJ Research Center, as well as Don Tamaki and Lisa Holder, to evaluate the relationship between this information and recommendations relating to Racial Justice Act implementation, as to whether those recommendations will go here or go in the Racial Justice Unequal Justice System chapter, unjust legal system. Next slide. Bunch Center report. Next slide. Curriculum, which we'll hopefully hear about a little bit more in the next meeting, but this is going to be recommendations around how to educate the public and what a curriculum may look like, or whether the recommendation will be a recommendation to the legislature that a curriculum be created and implemented. Next slide. And then this is the compendium of statutes and case law that contributed to the unjust legal system. And that'll be, that is a chart, that's an Excel spreadsheet. And so the task force will have to see that and make a determination as to whether that should be included as its own part or in an appendix in the next meeting. I think that's the end. So, galloped through that. That is the full final report. Those are all the components of the full final report. And we need, so we need a motion to confirm that as our full final report, or any discussion if anybody wants sections removed, reorganized, or added.
So I would like to see an addition. So when do we talk about that? Okay, so I would like to be added to Part 3 in the International Reparations Framework and Examples of Reparation Schemes. I like to see a section on genocide, and I would like there to be a historical analysis and a contemporary analysis as to how African Americans who descend from slaves may or may not be victims of genocide. So we can talk about, in terms of the historical analysis, we can cite the 1951 We Charge Genocide petition that was filed by human rights attorneys Paul Robeson and William Patterson. And then we can have a contemporary analysis breaking down the different elements of genocide, killing members of the group, causing serious bodily or mental harm to the group, deliberately inflicting group conditions of harm to the group, preventing births in the group, forcibly transferring children of the group to another. Those are the different elements of genocide. And so I think there needs to be a contemporary analysis of how African Americans may be victims of genocide post-1988. That's when the United States ratified the Genocide Convention. And I think and adding a conversation on genocide would only strengthen the argument for reparations on a state level, and then of course on a federal level as well.
We can do that research and work on a component of the draft as we're drafting on that issue.
Then another addition, I think,
Madam Chair.
sorry, Vice Chair Brown, you're recognized.
Also, maybe we should consider sharpening gentrification as a form of genocide. What happened in San Francisco was a public policy measure that intentionally and deliberately displaced a people. It happened to no one but black people. That's it. The population drops from 16% down to 4%. And the Wall Street Journal just 3 weeks ago came out with an article. Who are the top 20 worst cities for black folk? In San Francisco, the Bay Area was number 17. New York Times did an article 5 years ago. Blacks are made to feel lonely in San Francisco. And also John Steinbeck, that man who wrote that piece, you know, Grapes of Wrath, excuse me. He said this, and I quote him, "I wonder how many people I've looked at all my life and never seen. I looked at all my life and never seen." Many of these communities, they don't see black people. They don't see our humanity. They don't want to see us in existence. They looked at us, over us, and around us. rather than to see us. And that is psychologically, mentally debilitating. Psychiatrists have pointed that out. And we got to look at what is the real injury and harm that was done in these communities that were torn up. And we did not even have the luxury for protection of the Chinatowns, the Japantowns, and the missions. So those are the stark realities that you come up with when you stop, reflect, and look at how we don't see people, or we look at them as being inanimate objects and not persons.
Okay, so, yeah, thank you for that, Vice Chair Brown. So, I definitely think there should be a conversation on genocide, a historical analysis, and a contemporary analysis post-1988, when the United States signed or ratified the Genocide Convention. I think another, any other comments?
Consolidating, overlapping.
Oh,
Yes. let me
sorry.
bring
Member Tamaki, you're recognized.
Thank you. Couple things. First of all, I thought the outline on international reparations was really helpful. I think Camila has studied this for a long time, but to me, it was more new. And I think it frames our effort, because when the public understands what other groups and countries have gone through, it helps scale what we come up with. I like Pastor Brown's comment about the gentrification, and specifically urban renewal. I just want to add a point that Japantown followed the Fillmore 10 years later, reducing it from 44 blocks to 4. And my family lost their property and as the community was dispersed. So there's no equivalence between Japanese Americans, Asian Americans, and Black people whatsoever. But every now and again, we get a target on our backs too, as part of the dehumanization process. But I think that's beside the point. On the international reparations thing, it would help to have footnotes, and maybe those are going to be included. But I think the information is so solid that would be helpful. With respect to the consolidated proposals, can I raise a point, Chair Moore? So in each of the areas, there is some overlap. And so the question is, does the redundancy helpful, or does it tend to dilute our point? So for example, in housing, there's a discussion about food deserts, heat environment, lead pipe pollution, et cetera. And that is also repeated in almost the same language in the healthcare. And so I'm thinking if it's repeated like that, it tends to, in my view, kind of dilute the impact. And maybe for some of these where the reference is applicable, in one of the chapters, one or the other, there should be a reference and to say for discussion on the environmental impact on the Black community, see chapters thus and such. Here's another example. Maybe I'll ask Member Grills. That sort on the racial terror, thanks to you, chapter, there's a really significant deep dive into the mental health impact. Really well done. But healthcare proposal has sections regarding mental health and wellness centers and all that too. Are we better served by referencing one or the other to refer the reader to? And so we just say it once. And so it's not repeated over and over again. It's a editing, formatting issue.
And I would add one slight sort of addition to that, which is there are places where different advisory committees had proposals that are maybe slightly misaligned, not really directly in contention with each other, but misaligned with different recommendations. And I think when in the process of consolidating them, as Member Tamaki is talking about, reconciling the misalignment so that when we come out of this with a draft for you all to review, those proposals come to a set of recommendations that are aligned and the differences are reconciled.
Okay, so Member Holder, you're recognized.
Just for organization and formatting, a lot of this is, I don't know, subjective, but there are some places where it seems to me that, like, for instance, abolition of the death penalty should be under criminal legal. I saw a few things like that, and so I do think that the DOJ should just sort of go through it, with a fine-tooth comb to assess the logic of the placement of certain things. So that's just a recommendation.
Absolutely, and what we will also work through as it looks in the draft is potentially still having something in another section, but a cross-reference discussion somewhere else, so that it's still mentioned where different it may be still relevant, but really figure out the one place where it really should have the bulk of the discussion, and then reconciling all those different opinions, so all those different findings. I can go through a few more of the questions that we have for you. At the end of this, we're going to look for a motion that says basically, subject to this discussion, you all approve of the organization that we're proposing. So just to give you a heads up what we're looking for in terms of direction. We've resolved the apology question. For the wealth gap, we had a discussion in the last meeting from Dr. Lewis about the wealth gap sort of chapter maybe not having specific recommendations or those recommendations being related. Dr. Lewis, I think, prepared a short discussion, and I think we want to make sure that is what we'll include in the wealth gap, or if you would prefer to not have a wealth gap and have that be just in the expert report. Or if anybody else has any thoughts on the wealth gap separately.
Member Scott Lewis, you're recognized.
Is it really a question for me, though? I mean, I think it's not.
It's for the members. Is there any contrary direction? I guess that's what our plan is. Is there any contrary direction, or anything anybody feels needs to be in there otherwise? Okay. We mentioned the Racial Justice Act. I think there's Racial Justice Act is discussed in two components. One where we have the DOJ Research Center report and discussion. The other is in the unjust legal system. We will work through, I think our recommendation is for the policy recommendations, because they're coming from the task force, that they be housed in the chapter on the unjust legal system, and the Research Center report serve as the data and sort of foundation for the evidence of why those recommendations are needed, but stay in a separate report that is very clearly the sort of full report from the survey. We wanted to elevate that for everybody, but especially for the members of that advisory committee, if there's any contrary opinions or direction.
So are you proposing putting that into an appendix or a compendium, or having it as a standalone chapter? I just need clarification.
Sure. Having the survey that was done at the direction of the task force be its own chapter, the survey report and the findings from the survey report as one chapter, having the recommendations on the Racial Justice Act, because they're in two different parts, be consolidated into the unjust legal system chapter, but referring to the chapter with the Research Center's report, with the Racial Justice Act data report, essentially as evidence, rather than splitting those two issues.
Yeah, I think just to compress things a little bit, so the report doesn't get too unwieldy, which I would recommend definitely consolidating it under unjust legal system. And then in terms of the raw data and the raw report itself, just do that as a compendium or an appendix that you're referring to.
Okay.
That's my recommendation, instead of having it, the raw data or the data piece being its own chapter.
Okay. And then the final item is the legal compendium. The legal compendium is going to be a pretty lengthy Excel spreadsheet, and this may be probably a better item to decide in the next meeting. We are presenting that as an appendix because it is rather lengthy. It is in an Excel spreadsheet form. We're looking at different options for compiling it so that it looks good and readable and usable in a PDF form or in a printed form. And the question is exactly how, whether you want that entire report in or some kind of synopsis. I think you should see that before you make that final decision, but I wanted to highlight that as an issue that still needs to be decided. And that is the totality of our questions about the organization of the final report. I don't know if anybody has any questions.
I may have missed it, so forgive me, but did you include the Bunch Center report about where that would go? You did? I just missed it.
No problem. It's included as a chapter. We're going to take the entire Bunch Center and include it as
Okay,
a
as a
chapter
chapter,
because
okay.
Essentially it comprises the sort of listening sessions and community input and other issues into one item.
And then the other thing is that I'm not sure where we left off in the discussion about the universal versus special population, special consideration discussion, but I just want to make sure that we think very carefully about removing universal sounding recommendations. I just did a quick scan and found at least 15 things that would end up being removed, and that would be really problematic. I know that some people want to define reparations in a particular sort of way, but by removing some of these universal sounding or universal facing recommendations, the key word that we have to look at is the facing part, because while it may sound universal, it directly has impact and implications for African Americans, whether you're talking about, and we're talking about remedies, repair, rehabilitation, guarantees of non-repetition. For example, the death penalty, we are disproportionately represented. You can't just say no death penalty for Black people or African Americans and ignore everyone else. It has to be kind of stated as a policy. The same thing applies to education-based incarceration, increasing access to mental health services for people who are incarcerated, law enforcement activity in California schools, funding streams for mental health services in the jails and prisons, access to naloxone, which is Narcan, in the jails and prisons. By the way, if you do away with that, do know that Black folk are dying at higher rates in the LA County jails. We haven't looked at others. So we've got to be smart about how we get to our most vulnerable and protect them and make sure that they reap some benefit from reparations. And if we are very narrow in our thinking, we in fact may be excluding our most vulnerable. Is that what we want to do?
Member Grills, duly noted. Thank you for that contribution. Member Montgomery Stepp, you're recognized.
So I just want to get clarity. I know that you all, especially you, Mr. Newman, have gone through this over and over, but our next meeting, will that be the last meeting to provide any additional input? So I see yeses and nos over there. So I just want to know the process. I have quite a few very specific things, and I'm asking the question to see if I need to contribute those now or if I can contribute those at the end of this month.
So you read our minds collectively. Here is the schedule, and it's very similar to what we did last time. You have now, we've gone through, we got approval in the last meeting of all the recommendations. So the recommendations that are through to now have all been voted on, have all been approved to move forward. We are moving forward with the drafting. You all will receive a draft of the report in probably about 2 weeks. We're working on that. It'll have to be published before the next meeting. So you have an opportunity right now to provide feedback on what you've already received, which includes the outlines, which includes the previous sort of minor drafts of the briefing memos on the various components. You will get the draft of the report. You will have an opportunity, and in the next meeting, we were just talking about this, in the next meeting will be your opportunity as a group to actually go through the report. We're not going to necessarily go through it line by line during the meeting, but if you see in the report, the draft that you get before the next meeting, items that you do not want to go through, that meeting will be the last opportunity to actually pull things out. So during that meeting, there will need to be votes on anything that you want removed or anything that you want added in. It'll be the last opportunity to do that as a group, to actually vote to give us direction to do that. If there are words, if there are things like that you see and you want to provide edits to the Department of Justice in the draft, you can provide those both up to the next meeting and in the days after the next meeting, we will be able to implement them. If there are sort of major concerns, I think, like I said, we've sort of highlighted Black versus African American that came up in the interim report, and other issues like that. Those are pretty major issues. That's more than just drafting suggestions. Those should be raised in the next meeting and debated and voted on. If there are, for example, we've gone through the outline. There's a different way to organize the recommendations, which is instead of being tied to the chapters in the interim report, they can be thematic. We can talk about issues by theme rather than tied into the chapters of the first report. We are taking the direction that we're still sort of tied into the report, to the chapters in the interim report. If you believe that there should be a significant reorganization, that needs to be raised and debated and voted on in the next meeting. If there's any, like I said, if there's any other major components that needs to be added in, or a discussion point of a major component that needs to be removed, I hope not at this point, but if that happens, that needs to be voted on. So basically, coming out of the next meeting, we should have both your direction on finalizing the report, as well as your line edits for specific items in the report. And we will take those line edits up through probably a week or so after the next meeting. So next meeting is March 29th and 30th. The meeting after that is May 2nd. We need to publish a final report by the publication date or thereabouts for the May 2nd meeting. The May 2nd meeting is going to be a final approval of the final report. And then moving forward from that, we have our sort of final publication advisory committee that was put in place last time with the ledge staff, who are then going to help actually format final proof review edits, but no changes from that date on. So that's the schedule. I can go over it again if you want, but that's the schedule from here on out. I don't know if anybody has any questions about those.
I don't have questions at this time. Oh, Vice Chair, go ahead.
Did you have a question?
No, I have a quick comment. So everyone clearly understands my comment about universality. If my house is on fire, the fire department does not go to 3 or 4 houses on my block on Bright Street in San Francisco. I am a world citizen. I am concerned about the humanity of everybody. But the house has been on fire for far too many years for nobody but black folks. And that's why we have to be very careful to keep this task force's work focused on the area in the village where the fire is. You don't put the water all over the place. I hope we be sensible to that end, to keep this matter focused. We didn't get where we were supposed to have gotten in 1865. We didn't get it after the Kerner Commission report. And I can cite other instances historically. The question is, when are we going to focus on the folks who are the sickest and the house is on fire? And that's the reason why a reasonable particularity represents sanity and common sense. That's really why we got to keep this language. Letting the doctor know and the fire department know where the harm is, where the danger is.
Member Montgomery Step, you're recognized.
I just want to put one more thing on the table as an observation so far, and I'll use a couple of different examples. One is the paragraph that talks about the repealing the crime-free housing policies, where there is language, it says make affordable housing a fundamental right that allows for pro bono or legal representation in eviction proceedings. I really want the language to be more affirmative and not as passive, as far as instead of allows, requires, that we make that as a part of a requirement for legal representation when it comes to eviction proceedings for the descendant community. There's another, and that was on page 42 of the most recent copy. Page 98, when it talks about professional career training, there's another example of just some language that I feel like is a little bit more passive and I want to be affirmative wherever we can. It talks about descendants who receive financial wealth training should be encouraged as a part of their professional development to engage in pro bono training. And then it goes on. I would rather it say should have access to pro bono training instead of be encouraged. I want these things to be provided in the proposals that we submit, as opposed to leaving leeway for any kind of services that the state will get out of trying to provide. So those are two examples, but as those come up in your reading, then I hope that we can kind of make that language a little bit more strong. Thank you.
Our dedicated DOJ staff is here and hearing you, and I'm sure they will make sure that we are using more affirmative language on this as we're drafting. And I'm telling them to.
Also, I think we can talk about this at the next meeting, but I think we need to be tracking pending, a particular pending U.S. Supreme Court cases, the 2 affirmative action cases before the Supreme Court, and then Holland versus Brecken, which is tribal law oriented, but may have some implications for the work that we're doing. I think the Supreme Court is expected to give decisions out on those affirmative action cases and Holland versus Brecken before the task force ends. I'm personally tracking, but I'm just putting on record that I think if the U.S. Supreme Court does come to some decisions around those cases, there may need to be a conversation in our report around those cases as it relates to the beneficiary class. I'm more than happy to provide more context at a later date, but putting that out there for the record.
We'll keep that in mind. We're going to track the Supreme Court's docket, and we'll see, depending on the timing of the final report. So we need a motion that authorizes us to move forward with the drafting of the final report, subject to all of the input here today, which we will make sense of by reviewing the recording.
Second.
It has properly been moved by Member Tamaki and properly seconded by Vice Chair Brown that we adopt the existing organization and formatting of the final report, subject to all the different additions that we discussed here today. Is there any discussion on the matter? Hearing no discussion, I'll turn to Parliamentarian Johnson for a roll call vote.
Thank you. I will start with the vote with Madam Chair.
Aye.
Madam Chair votes aye. Vice Chair Brown.
Aye.
Vice Chair Brown votes aye. Member Bradford. Member Bradford is absent. Member Grills. Aye. Member Grills votes aye. Member Holder. Aye. Member Holder votes aye. Member Jones Sawyer. Member Jones Sawyer is absent. Member Lewis.
Aye.
Member Lewis votes aye. Member Montgomery Steppe.
Aye.
Member Montgomery Steppe votes aye. Member Tamaki. Aye. Member Tamaki votes aye. Madam Chair, there are 7 members present and voting. There were 7 ayes, 0 nays, and 2 absents.
There are 7 ayes, 0 nays, and 2 absent, and thus the motion carries as the ayes have it. All right, so the next item on the agenda is, so we're waiving the advisory committee report backs, correct? Is that what we're doing?
Yes, and just to clarify, I said this earlier, which is the advisory committees have performed their duties, they've drafted the recommendations, and the advisory committees are done with their work, which we thank everybody for all their work on the advisory committees. It was incredible work. We really appreciate it in the DOJ, all the great clarity and direction we got, and everyone's hard work in developing the recommendations. Now it shifts to individual task force members reviewing the draft, providing us feedback on an individual basis, and then task force votes, like the one we just had, to the end.
We'll say in terms of the agency vote, there's still some work that potentially needs to be done, because in the proposal that I gave, it was for an agency, not simply an oversight commission, but an agency that will provide direct services and oversight power. And so I would probably need some assistance from the California DOJ, the folks who are on that particular advisory committee, to ascertain where there is overlap, which so-called branches to strike, right? You all would have that information more than I would, so I would need some assistance on that.
Yeah, well, we will. We were taking all of everything that you all are saying today. We followed the whole debate, and we will be implementing that, and everyone will be able to review and give input. Once we circulate the draft, we'll be very happy to take everybody's input and be informed by the vote of the task force.
Yes, just noting there's just going to be a little bit more work required for that to fulfill the spirit of the motion that passed from the California DOJ. So the next item on the agenda is recommendations to the legislature for urging federal action.
This was an item that we were requested to add to the agenda at the last meeting in order to have a discussion as to whether there are any recommendations that the task force would like to make with regard to inclusions in the final report of recommendations to the federal legislature, Congress.
Holder, you're recognized.
I think that this is a very important topic, and I understand that at this point we are under the gun, but I don't know that this is the best forum right now for, elucidating on that. I would recommend that we either do another advisory team to grapple with that over the next few weeks, or use some other process.
Well, maybe I'd recommend we do it this way. If anybody has any suggestions, and again, to clarify exactly how this would be framed, it is recommendations in the final report to the legislature, for the legislature to issue the sense of California of federal action. So it wouldn't be a recommendation directly from the task force to the legislature, to the Congress. I keep calling it the federal legislature because we've got one here. The idea is, if you have inclusions like that, why don't you send them our way? And we can include them in the draft report, and they'll be factored into the recommendations. Again, now we're past advisory committees, so anybody who wants to can send to us those recommendations, and we can highlight them for everyone's review. And again, if people want them removed at the next meeting, we can do that by vote.
Okay, and how long do we have to do that so that you can have a list prepared by the next week meeting?
That's a tight time frame, because we have a short interval before the next meeting. We really need it by the end of next week, and it would probably be in list form. And it may not need more than that, because it's just a recommendation that the legislature express support for this bill or this action or something like that. And it would not need to be elucidated further.
So, on page 19 of the interim report, the preliminary recommendation was to transmit the task force's final report and findings to the President of the United States and the Congress, with the recommendation that the federal government create a reparations commission for African Americans / American freedmen through statute or executive action. So I need clarity in terms of, are you saying that preliminary recommendation cannot be transferred over to the final report, or it has to be restructured for that recommendation to be directed to the state legislature?
It would have to be restructured for all recommendations to be to the California State Legislature. So you could have the California State Legislature include in its final action, legislative action that it takes, something about that, something about expressing the sense of California that the Congress should do X, Y, or Z.
So my suggestion would just retain what's in the preliminary report and just restructure it so that it's, instead of a direct recommendation to the President of the United States and U.S. Congress, it's directed to the state legislature to make that, recommendation to the President and U.S. Congress. The spirit of the recommendation is already in the interim report.
Sure.
So yeah, just to clarify, page 19 in the executive summary of our interim report, there is a preliminary recommendation to transmit the task force's final report and findings to the President and the U.S. Congress, with the recommendation that the federal government create a reparations commission for African Americans or American freedmen through statute or executive action. So we're saying that we can no longer make a direct recommendation to the U.S. President or Congress as it's currently written in our interim report. We have to restructure that recommendation and ask the state legislature to make that recommendation to the U.S. President and Congress.
That's correct. We will do that.
Okay, great. I think that covers everything. Any other comments on it? All right, hearing no other comments or questions, we will turn to the next item on the agenda, which is the next meeting agenda, which is on the screen.
And I think one item is, you voted previously in this meeting to return in person. One of the motions that was tabled, or one of the issues that was tabled, was locations for the next two meetings. So that is, there's future meeting dates is the next agenda item, and we've done this several meetings, but one of the things that should be resolved in terms of location, one of the things that should be resolved is location, and that will impact the agenda in terms of if you want to invite locals from whatever location we are in to provide testimony. The DOJ, I think several people have mentioned this room has been good. So this is, I don't know if we've confirmed, Trini, have we confirmed if the room is available? No. Have we confirmed if this room is available? No. Okay. No, I can't confirm it until Monday. Okay. So we would be able to confirm on Monday whether or not this room is available for the 29th and 30th, but if that's your direction, let us know. Otherwise, if there's a different location for either of the meetings, let us know what your sense is. Do you need a motion? Well, yeah, we'll need a motion to set the agenda as well as to set the agenda and the locations. And just to clarify, there was no motion on the June 30th meeting being in Allensworth. So we need to resolve, this is months ago, we talked about that being a potential final meeting. But that was not, I think we've looked back at our records and there was no actual motion that set that location. So what's before you is resolving the location of the March 29th and 30th meeting, May 2nd meeting, and June 30th meeting.
Thank you. So maybe we could take these dates a little bit backward. I think it's the last day of session, June 30th, in Sacramento, which means Bradford and Joan Sawyer are going to be really, really busy. I think it makes sense, unless I'm missing something in terms of media coverage, to have it in Sacramento because there's a symbolic nature to have it here, given it's this, the state capital. And we're talking about harms caused by California. And then the other thing is we need Joan Sawyer and Bradford here. And yet that's the last day of session, so they're going to be extremely busy. So I would, if necessary, make a motion that at least for the June 30th meeting that be in Sacramento in this, location. And that the media coverage be centered around that, and we build toward that date for that. As to May 2nd and March 29 and 30, I think media considerations are still front and center. I think we're getting, like I said, the amount of attention we're getting is crucial. So for that reason, and I think I mentioned this yesterday, as much as it would be great to do this in Allensworth, I think we need to do it in a major media market. So to me, that's Los Angeles. And so March 29, maybe 30th in Los Angeles, maybe May 2nd back in Sacramento, and June 30th on Sacramento, something like that. I just throw that out for discussion.
I move that we establish those dates.
Well, dates are established, the locations just need.
I mean, I'm talking location. Wait a minute. I'm moving dates. Place.
Is there a second?
I didn't hear the motion.
The motion was to approve the locations that Member Tamaki proposed for the various dates. Second. Hearing no second, the motion fails.
Oh, sorry, I will second it. I thought somebody else would do it. I'll second.
Okay, it's been properly moved by Vice Chair Brown and properly seconded by Member Tamaki, that the March 29th, 30th hearing be in LA, the May 2nd hearing be in Sacramento, and the June 30th hearing be in Sacramento. Is there any discussion on the matter?
I'm sorry. I just talked to Damon about sort of a logistical issue and the quick turnaround. I mean, the DOJ staff is under enormous pressure. As we can imagine, we're racing to this deadline. So can you explain that? Well,
I just asked Member Tamaki if he had any objection to switching the meetings where the 29th and 30th meeting would be here in Sacramento, the May 2nd meeting would be in Los Angeles, and then back in Sacramento for June 30th. And the reason for that is because we were anticipating a virtual meeting for the March 29th and 30th. Logistically, it would be easier for DOJ to achieve an in-person meeting because we are based here in Sacramento under such a short deadline to do that for this next meeting, and then we can go to any other locations for the remaining meetings.
so can I amend my motion and then ask for a second, or without being hyper-technical, Dorothea? All right, so let me amend my own motion. So the locations will be March 29th and 30th in Sacramento, May 2nd in Los Angeles, June 30th, Sacramento.
Second.
So it has been properly moved by Member Tamaki and properly seconded by Vice Chair Brown that the March 29th and 30th meeting be in Sacramento, May 2nd in LA, and June 30th in Sacramento. Any discussion? I will just put out in the record, we've heard many folks on the community ask for us to go to the Inland Empire, where there is a critical mass of Black folks. And so I think March 29th and 30th be in Sacramento, I think that makes sense logistically, I guess, for the DOJ's convenience. I kind of wish that Senator Bradford and Assemblymember Jones Sawyer was here because they can kind of speak to their availability for June 30th. Because I was going to suggest that March 29th and 30th would be in Sacramento for logistical reasons. May 2nd could potentially be in the Inland Empire to satisfy that need from the community of eligibility. And then June 30th could be in LA. Because I understand the symbolism of Sacramento being the kind of final meeting, but when we talk about like where Black folks really are and like where they can go, it's like LA would be that place.
So just a suggestion that since it's the May meeting that would be in contention, then maybe we don't decide on the May meeting right now. We can wait until our next meeting to decide where to hold the May meeting. But at least we can give them direction on the next meeting at the end of March and the final meeting in June.
Well, I was suggesting the final meeting be in LA, not Sacramento. And then I was suggesting the May meeting be in Inland Empire, and then the most immediate meeting be in Sacramento.
Well, then let's just make a decision regarding the most immediate meeting.
I do wish Bradford and Member Jones Sawyer were there, but that's the last day of session where they have to be here, is my understanding. So that's, it's just a peculiarity of the way the legislature and the timing, and so they can kind of drift in and out. But on the key presentation and all that, it's great. I mean, we need a full task force. So I think that is I think it's necessary, basically. And that's the driver for the meeting in Sacramento.
So the motion on the floor is for March 29th and 30th to be in Sacramento, May 2nd to be in LA, and June 30th to be in Sacramento. Any discussion on the matter?
Madam Chair, I apologize. I just learned that both legislators would need to be in Sacramento on May 2nd. And so because that is the meeting where the final report is being approved, and they are going to be the ones who have to shepherd everything through, it really is critical to have them present. So I know we're playing sort of a game of shuffling cards here, but that May 2nd would have to be in Sacramento in order for the two legislators to be present.
So essentially, March 29th and 30th, Sacramento for the convenience of the DOJ, May 2nd in Sacramento for the legislators, and then it would be up in the air for the last session, but essentially, Member Tamaki is saying that would have to be in Sacramento
I
as
think so
well.
too, yeah.
And I also learned that for the June 30th, the members may not necessarily be tied to Sacramento because the budget will have already been submitted. So they may not have to be here in Sacramento on the 30th when the governor signs it. So we may have more flexibility on the location for the June 30th.
And so the DOJ really couldn't make Inland Empire work for March 29th and 30th, like at all? Because we don't even know if this room will be available for March 29th and 30th.
Yes, but I have other options, less than 30 days to pull together travel and. There's less than 30 days to pull together travel and all the plans that need to be made for a meeting of this caliber.
Yeah.
All right, we ought to be practical, okay. So, well, the motion still needs to be amended then because of the May 2nd thing, because I don't think in your motion, May 2nd was Sacramento. Was it? I don't think so.
I've lost track of this. So Damon and Michael, can you? Sacramento for May 2nd. Sacramento for March 29 and 30. May 2nd, Sacramento. And June 30th can be?
Let's just leave it open. Let's just leave it open until cited.
Leave it open. All right, maybe this, Chair Moore, might be a possibility. And again, I'm not going to put in a motion, I'm thinking out loud with you. So March 29, 30th, Sacramento. Because the logistics to drive this thing, May 2nd will be in Sacramento, again, because of issues on getting the report done and availability of the two legislators. And then June 30th will be open until we get more information. And it could be, for example, in Los Angeles. Yeah.
That's good, thank you.
So that would be my motion.
I have a quick clarifying question. Why is the next meeting so soon?
That's when you had, sorry.
Doodle poll.
That was based on the availability. When we were determining quorums, those were the two dates that we had the quorum for the group.
We thought we were going virtual. So, but okay, everyone's fine with meeting by the end of the month in person in Sacramento. All right. So let's go to roll call vote. Parliamentarian Johnson, and the motion on the floor is for our next meeting to be March 29th, 30th in person in Sacramento, May 2nd in person in Sacramento, and June 30th location would be to be determined.
Yeah.
Chair Moore?
Aye.
Chair Moore votes aye. Vice Chair Brown?
Aye.
Vice Chair Brown votes aye. Member Bradford is absent. Member Grills?
Aye.
Member Grills votes aye. Member Holder?
Aye.
Member Holder votes aye. Member Jones Sawyer is absent. Member Lewis? Member Lewis is aye. Member Montgomery Steppe?
Aye.
Member Montgomery Steppe votes aye. And Member Tamaki?
Aye.
Member Tamaki votes aye. Madam Chair, there are 7 members present and voting. There were 7 ayes, 0 nays, and no abstentions.
Thank you. There are 7 ayes, 0 nays, no abstentions, and thus the ayes have it and the motion carries. Our next meeting will be March 29th and 30th in person in Sacramento, then May 2nd in person in Sacramento, June 30th to be determined. Okay, so the next item, which I think is still on the board, is to approve the next meeting agenda. I had a question for the next meeting agenda, item number 19. I believe is still like a contemplation of the advisory groups. If we're done, should that still be on there? Does it need to be deleted?
Yes, the agenda is crafted based on what exists before the various votes. Now you've all voted, and so we will craft an agenda that sort of mirrors this agenda that essentially goes through the presentation of the draft report like we did last time. So it won't be broken down by the various advisory committees. It'll just be broken down probably by chapters within the parts.
Okay, so it'll be updated. So 17 and 19 will be changed or
And we'll
modified.
provide that to you, obviously, for your approval, your and Vice Chair Dr. Brown's approval as well. I think the questions are in terms of if there are any modules that you want, or experts, other than the presentation of the draft report. Obviously, we're presenting the draft report. There's not a lot of capacity to add in more new things. So if there are any subject matters that anybody wants specifically discussed other than going through the draft report, do you want to invite witnesses?
Can you say that towards the end? What did you say?
Do you want to invite witnesses?
I think there needs to be room to invite witnesses if need be, but maybe not. Oh, Member Tamaki, you're recognized.
So assuming the silence means that no one has particular witnesses in mind, I wanted to add possibly an agenda item. I think we have to approve the proposed terms of the curriculum developer contract. So I think that has to be on the agenda. So just to let the task force members know, on March 8th, we will be discussing sort of proposed budget and contract terms with Professors Travis Bristol and Talani Martin, both PhDs at UC Berkeley. And so the Public Education Committee will then be shaping that and then hopefully get it into the basic terms that could be approved for a contract. So that would be on the agenda. Do we need a motion for that?
No, I don't think so. I mean, it's on the draft, so it's just a matter of reorganizing. The only other item that made me think of in terms of being on the draft that's still under discussion is the report on the Racial Justice Act data from the Research Center report, to the extent you want to provide a report out on your findings and recommendations. If there's no, so in order to agendize new witnesses or anything like that, we would need to get that now. And obviously, again, I'm restating, is a very short turnaround. And so the date to get us witnesses is like Monday. So I don't know that there's any witnesses remaining that we would need to get. We obviously had Sacramento people here at this meeting, so we don't need to be duplicative. I just wanted to make sure that it's clear whether or not we're doing that in the next meeting or reserving the time for the report, which obviously, as you can tell, we used a lot of time on the report today.
Okay, so we don't, because of the quick turnaround, it's not feasible or practical to necessarily invite witnesses for this upcoming meeting, maybe for May 2nd or a later meeting, but I think it's pretty clear that, it's not going to be feasible this time around for March 29th and 30th. Okay? It's doesn't need to be a motion for that. But in terms of the next agenda item, for the next meeting, I wanted to potentially entertain a motion to extend public comment for our future hearings. It could look like an additional 30 minutes. It could look like an hour in the morning, an hour after lunch. But I do think these next remaining meetings, community input is more important than ever. We're in the middle of the development stage. And so we're not going to be hearing from witnesses per se that much as we have in the past, which means we need to hear more from the community. And so I wanted to, I think Senator Bradford mentioned this too in the break, around the idea of extending the public comment period for the remaining meetings. But that would need to be agendized and voted on.
Madam Chair, you and Dr. Brown approved the agenda, so we can send a draft, and if you want to adjust some of the time frames within that, that would be acceptable.
That easy. All right, sounds good to me. Okay, so I think the agenda is set for our next meeting with the modifications as we just discussed. I will now turn to, we have to vote actually, because it's listed as an action item. So we would have to vote to approve the agenda. Parliamentarian Johnson? Parliamentarian Johnson? Oh, sorry.
Sorry, we're discussing whether a vote is necessary.
Oh,
Just 1 second.
okay.
Okay, we do not need a motion. We're just going to we want to make it notice of the public here, and then they'll get notice when the agenda is posted that public comment will be extended. That we're good.
And about approving the next meeting agenda. On the agenda, it's listed as an action item. So we need to entertain a motion to approve the next meeting agenda, correct or no? Parliamentarian Johnson? Yes. Okay. So is there a motion? Actually, I'll just do it. I'll introduce the motion. I move to approve the next meeting agenda with the modifications that we just discussed. Is there a second? It's been properly moved by myself and properly seconded.
Said, do you need a motion? I didn't know you were going to make the motion. So I would entertain a motion for that.
I move that we.
Thank you.
It has been properly moved by Vice Chair Brown and properly seconded by Member Montgomery Steppe that we approve the meeting agenda for the March 29th and 30th hearing with the modifications that we discussed. Which include, but are not limited to, we're not inviting any witnesses. We will be extending public comment. And items 17 and 19 will be modified in light of the work that has been completed by the advisory committees thus far. Is there any discussion on the matter? Hearing no further discussion, I'll turn to Parliamentarian Johnson for a roll call vote.
I will call the roll now for the vote to approve the agenda with the modifications regarding the time of the public meeting and the substance. Chair Moore?
Aye.
Chair Moore votes aye. Vice Chair Brown?
Aye.
Vice Chair Brown votes aye. Member Grills? Member Grills votes aye. Member Holder? Aye. Member Holder votes aye. Member Lewis? Member Lewis votes aye. Member Montgomery Steppe? Aye. Member Montgomery Steppe votes aye. Member Tamaki? Aye. Member Tamaki votes aye. Madam Chair, there were 7 members present and voting. There were 7 ayes, 0 nays, and 0 abstentions.
Thank you, Parliamentarian Johnson. There are 7 ayes, 0 nays, and 0 abstentions, and thus the ayes have it, and the motion carries. The second to last item on the agenda is item number 24, unfinished business. Is there any unfinished business? So the next item on the agenda is task force member closing remarks and meeting adjourned. Thank you all for coming. We'll see you at our 14th and 6th in-person hearing in a few weeks, March 29th and 30th in Sacramento.
Madam Chair, I'm sorry. Before you, I know you were right about I just wanted to acknowledge Senator Bradford and his staff for hosting this meeting and providing refreshment for the task force and the DOJ staff, and as always to the DOJ staff for their administration. We appreciate that.
And thank you to the public as well.